Good morning, everyone. I am Chair Aguiar, and this is the Board of Appeals September 9th, 2022 meeting held virtually using the Zoom platform. I'd like to review a few protocols with all participants before we get started. And if I may just rattle off a list of items. 1, all cameras must be turned on at all times during the hearing. 1 person speaks at a time with no side conversations. Mute your device when you are not speaking to improve audio quality for all. Raise your hand either virtually or on screen and wait for recognition by myself before speaking to ensure we make a clean and clear record of your speaking. Prior to speaking, please state your name so that all parties know who is speaking. Speak slowly, clearly, and be close to your microphone. Limit distractions, for example, turning off mobile phones and other devices. We do have a very full calendar, so we will do our best to get through everything accordingly. And as such, we may take a break each hour or as appropriate, depending on the matter being heard at the time. I'd now like to introduce our Board of Appeals members. And present today is myself, Chair Stacey Aguiar. We also have with us Vice Chair Richie Henderson. You want to wave at us, Richie? Thank you. Board Member Matson Davis. And some of our newer board members, new board member David Wiseman. New board member Dana Noe Saiki. And excused today is board member Richard Cunningham. Also present on this call and with us is our Board of Appeals Deputy Corporation Counsel, Cody Friends. Morning. And Board of Appeals staff members April Suprenin and Kim Tanaka. Now we'll take statements from the public on items on the agenda for public testimony. Public testifiers, can you testify now or prior to the agenda item they wish to testify on? And Cody will be keeping time. Everyone will get 3 minutes, and at 2.5 minutes, Cody will announce as such that you have 30 seconds remaining. Kim, do we have any public testifiers at this time?
Please resend the link. I signed up last night, but now it shows me as being under Ian Meyer because he had to send me his link. I signed up at 9:35. Please send me a link by email.
Ms. Rohr, this is Cody Friends, Deputy Corporation Counsel speaking. We aren't able to do that right now, but we will change the name to reflect your name on the Zoom in a moment. You should see that change. Okay, ma'am?
Ms. Rohr? Okay. So we'll go back to public testimony. We're checking right now if there are any public testifiers in our Zoom waiting room.
All of these are parties or witnesses to a defense.
So we have no public testifiers at this time in this portion of our hearing. So right now I'd like to take one matter out of order, as I understand that we have a board member that will be disqualified from hearing a couple matters on our calendar, and I'd like him to be able to vote. I'd like to take approval of the minutes of the January 14th, 2022 Board of Appeals meeting out of order. Having all board members, whether you are present or not, have all board members, whether you are present or not, reviewed the recording of the January 14th, 2022 hearing and reviewed the associated minutes.
Yes, I move that we accept the minutes as circulated.
Second the motion.
Thank you. That was a move by Chair
Richard Henderson.
Henderson and a second by Mr. Wiseman. Thank you. Can I get a, is there any discussion? Seeing none, all those in favor of approving the minutes of the January 14th, 2022 Board of Appeals meeting, please say aye.
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 Board Member Psyche? Thank you.
And aye, Chair Aguiar. All those opposed, please say no. Not seeing none, motion passes. We're going to start, excuse me? Okay. We're going to start with our old business now, calling the matter for Ian Myers. And it is the matter Ian Myers, PL-BOA-2021-000008, adoption of findings of fact, conclusions of law, decision and order. Appeal of decision by the Department of Public Works Director regarding notice of violation and order. Location 75-437 Hualalai Road, Kailua Kona, Hawaii 96740, TMK 3-7-5-017:008. I'd like to take note that I believe one of our members has a conflict in this case. Is that correct?
Yes, that would be correct, Richie Henderson. So I would like to recuse myself from this case hearing.
Okay, Richie, since you are recusing yourself from this matter, can you please mute your mic and turn off your camera, and we will let you know when you can rejoin us.
Thank you, Chair Aguiar.
Thank you. April, are there any public testifiers on this agenda item?
No, Chair, there's none.
Pardon me. So can I get the names and appearances of the parties for this matter, starting with Mr. Myers, please, from the department? Oh, I'm sorry, starting with Mr.
I'm
Myers.
sorry, I got disconnected. I'd like to say something about Richie Henderson recusing himself. A comment, please.
Sure.
I haven't associated with Richie Henderson for 20 years. And he is a born-again Christian and probably the most fair person I know. And there is no reason why, if he voted against this hearing, that he would have to worry it would change our relationship, because we have no relationship anymore. I just want it on the record that Richie, I feel as though having someone who is honest, religiously honest.
I'm going to interrupt, Ms. Rohr. This is corporate. Hold on.
I
Ms.
feel
Rohr,
it's
Ms. Rohr,
inappropriate for you
Ms.
to
Rohr.
interrupt me, please.
Yeah,
I'm
this is,
finishing.
I'm not
Ms. Rohr.
interested in the opinion of Mr. Henderson at this time. It's a
Thank you,
recusal
Chair.
is a very subjective thing. And if he feels he can't continue with this, that's his choice. We don't need
Right.
comments on it.
Thank you,
Absolutely.
Member Wiseman. Yes.
Thank you. It is the
I just
discretion
wanted
of
him
board
to
member. It is the
reconsider.
discretion of each board member. Thank you, but it is the discretion of each board member to decide to recuse or not, and the matters in which they recuse and the purposes of which they recuse themselves is their choice. Thank you.
So Ms. Rohr, I need to say one thing. Ms. Rohr, you are muted on our end, so please take a moment and let me finish speaking. We all need to make sure that we make a clean and clear record today. So if there are times that someone attempts to interrupt to say something that needs to be said, it's important we all pause so that we can respect each other and make sure that when there are objections or interruptions, we pause. So Ms. Rohr, I was attempting to do that. Please, going forward, ensure that everyone is afforded a chance to speak. We understand that you wanted to make your record. You were afforded that opportunity. Repeating and continuing beyond what's necessary will be interrupted, and we need to all work together to afford that opportunity to occur. And as has been very clearly established, your opinion has been noted for the record. It's the board member's discretion, and it is not revisited at this time. So we're going to move on. Go ahead, Chair.
So back to the names and appearance of the parties for this matter, starting with Mr. Myers, please. Can you please announce yourself?
Mr. Myers, Ms. Rohr, that's you.
And you have to unmute.
Mr. Myers, you need to unmute. There is a microphone mute button on the bottom left of your screen. You click that and it will, and then also start your video. Bottom left
Ms. Rohr, your
corner
video
of your
on.
screen. Go ahead and unmute your video.
Can you do the same, Ms. Rohr?
How's that? Can you hear me now?
Yes.
We cannot see you. Could you unmute your video for the first 5 minutes and then, or so?
Sure. I did unmute it, but I can see you guys, but I can't see myself.
Can you start video, sir?
Where is that again?
Bottom left corner.
All I see is mute.
Okay, I think
Okay.
the problem is that I had to sign on using his login. And I asked that you please send me the link that I
You are
signed
now
up for last night.
I think it is working, and we're fine with Mr. Myers introducing himself. We can see him live and hear him live on our screen. Thank you.
Where? Hold on, let me see.
I don't
No.
see me.
No, he's not there.
So that's, this is Corporation Counsel Cody Friends speaking. I believe he might have a camera issue, Ms. Rohr, and we are unable to send you a new link because you personally need to register and you get the link, ma'am. That's out of our control. So
I
if
have
Mr. Myers-
registered. I registered
So then
last night at 9:35.
Great, please use that link, ma'am.
You know what? It linked to some sort of website, and I don't have that website up on my screen anymore.
That's okay, Ms. Rohr, because we can see you just fine. So
we would like to
have-
have Mr. Myers seen face to face, and I don't believe it's fair.
You are his representative, correct, Ms. Rohr?
Yes,
You are
and
speaking for him?
we
Great.
made a point last, I'm not even on the Zoom anymore. I don't know where these go.
See you, Ms. Rohr. We can see you, Ms. Rohr.
There you are.
Oh, here, I found my link. I'm going to sign up, and then somehow you'll have to I have to sign out of the other one. So I'm gonna.
Mr. Myers, do you have a camera on your laptop or?
I sure do. I sure do, sir.
laptop?
Okay,
Yes, I do.
there. Let me sign out. I'm not sure how to do that.
Click
You'd have to
leave.
leave.
Bottom
You have-
left, bottom right corner. It says leave, a
Leave.
red button.
So, Mr. Myers, you can also leave and log back in and see if that operates your camera.
Okay.
You don't have anything covering your camera, right, Mr. Myers?
I think he left.
Oh,
So we are taking a 3-minute break.
no. Mr. Myers is coming back. Mr. Myers, I see your square again. You want to try and unmute and go ahead and start your video, sir. So it's the same thing, Mr. Myers. You still have a black box. I'm guessing it's something on your end, sir.
I don't see why.
That's okay. Are you comfortable just speaking with us again today, sir?
I would like to be able to see me.
So you need to fix your camera on your end, Mr. Myers. We have no control over that, sir.
Hmm.
I can hear you.
Okay.
And actually, Mr. Myers, in a January 14, 2022 hearing, we did not see you either, sir. We only heard you. I've rewatched
Right,
the
that's,
video.
yes, that's why I'd like for you people to see me. So I'm very
So
sorry
please
about
fix
this.
your camera, sir. No
Yes,
problem.
right now. Please forgive me. Yeah, I don't know what it is. I pressed start video and it's not going.
It might
Sorry for the hold
be
up.
that, it might be that your computer does not have a camera.
No, it has a cameraman.
Might be disabled.
I think you need
Maybe
to go
your
into
camera-
preferences and get the camera to be recognized by the computer as an option. So do you have somebody else in the house that might be able to help you?
Yeah, I'm alone. Sorry.
Another option might be, we have your land planner / representative has not rejoined the meeting using her own link yet. We
Yeah,
are
she's-
several minutes into this, and we do have a very large calendar, Mr. Myers. So
Yes,
if we
ma'am.
don't get this squared away soon, either we're gonna ask our conflicted member to rejoin us and push your matter off until you can figure it out and Ms. Rohr can rejoin us, or you're gonna have to proceed as is, sir.
Okay, could you hang on for another couple of minutes to see my planner get back on? I'd appreciate it.
Sure, sir. Yeah.
Mr. Myers?
Yes,
This is
ma'am.
Chair Aguiar. Seeing that Claudia Rohr, your land planner, has not rejoined us, we'd like to postpone you and hear some new business, invite our recused member back into the room. We'll put you folks in the waiting room, and after our next case, we will revisit with you to see if you are able to fix your camera.
Okay, appreciate it.
Okay, thank you. We're gonna move you off of Zoom into the Zoom waiting room right now.
All right,
Thank
sorry
you.
about that.
No problem, thank you.
I'm gonna sign off and try to work on my camera and then sign back in, okay?
Perfect.
And I
All right.
suggest you also get in touch with Ms. Rohr, Mr. Myers, because she has
I
not
will.
rejoined us. And if she's not back at the next time, we're going to need to address how to proceed. We also have Deputy Corporation Counsel Sinclair Solis Ferguson via Zoom. Mr. Solis Ferguson, we're unfortunately also going to have to send you to our waiting room for now, sir. We'll get in touch with you when we are ready to recall your matter. Apologies.
Yep. Sorry about that.
No problem.
No
Thank
problem,
you.
Mr. Myers. Thank you,
All
sir.
right,
We'll see you
thanks.
soon.
Okay, thank you for appreciating it. Thank you. Bye-bye.
Of course.
Thank you.
Mr. Henderson, Vice Chair Henderson, if you're able to hear us, can you rejoin us, sir?
I can hear you.
There you go.
Thank you.
Thank you.
Okay, you ready for the second one? Because I need to let people in.
Yes. You want to let them in?
Yep, I'm doing that. I'm gonna start doing that.
Thank you. So moving on to new business, we're going to call a couple of matters out of order for private counsel. New business, we will start with agenda item number 2, Sanjeev Kaila, PLBOA 2022-000023, appeal of decision by the planning director related to a short-term vacation rental, location 78-6874, Kuhinanui Street, Kona, Hawaii 96740, TMK 3-7-8-021-016. And we will hear this in conjunction with case item number 5 on the agenda, Nazar Holdings 13 LLC, PLBOA 2022-000029, appeal of decision by the planning director dated August 2nd, 2021, regarding denial issued for short-term vacation rental registration, STVR 19-365097, and non-conforming use certificate, NUCR-20-1780, location 78-6874, Kuhinanui Street, Kona, Hawaii 96740, TMK 3-7-8-021-016. April, do we have any public testifiers on this agenda item?
No, ma'am, we do not.
So no public testifiers. Can I get the names and appearances of parties for this matter, starting with the appellant and his counsel, please?
Good morning, Chair Aguiar and the members of the board. Joanna Ziegler on behalf of Nazar Holdings 13 LLC. I do not see the representative of the LLC on the Zoom call, although I know they did register, but I am prepared to move forward with the arguments on the motions.
Great, thank you. And from the planning department?
Good morning, Deputy Corporation Counsel Susanna Tiapula for Planning Director Zendo Kern.
Thank you. Can I go on? I'd like to note for the record that the parties have agreed to consolidate these two matters for efficiency purposes with today's pending motion. Before the board today is only the motion to dismiss filed by the planning department and an opposition filed by the appellant. We have read all of the relevant documents. Do the parties have anything else they would like to say?
Nothing further from the county.
Sure, I'd like to just note a few items and highlight some undisputed facts based on the motions. As you noted, there was a motion to dismiss filed by the planning department and then a motion for summary judgment filed by appellant. There are several very important undisputed facts that I'd just like to highlight for the board in this case that support the denial of the planning department's motion to dismiss and granting the motion for summary judgment. With regard to these undisputed facts, first on December 26, 2019, the planning department did approve appellant to operate a non-conforming short-term vacation rental and issued a short-term vacation rental registration number and a non-conforming use certificate. And then on June 10th, 2021, the planning department acknowledged receipt of appellant's renewal packet and requested further information based on items 5, 6, and 7 listed on page 2 of the renewal packet. Through a series of email communications, the planning department allowed appellant to submit additional information by July 22nd, 2021. And then on July 10th, 2021, appellant did submit additional information that included the payment of the GET and TAT taxes and proof of continued use of their short-term vacation rental and the correlated tax payments for that continued use. Appellant later received information from the tax department with regard to their GET and TAT certificates and then the tax clearance, which satisfied all of the requested supplemental information from the planning department. And then in August, the planning department apparently did send a denial of the renewal for the non-conforming use certificate, but it is admitted in the planning department's motion to dismiss that the denial letter was sent to the wrong address and appellant never received that denial letter. So with regard to the planning department's motion to dismiss, there are serious due process concerns, and that is because the denial letter did not ever reach appellants and they were never given an opportunity to have notice regarding that denial and an opportunity to be heard. The planning department's motion to dismiss is based on what it characterizes as an incomplete notice of appeal. However, when looking at all of the facts in its entirety and the context, appellant was unaware that its denial letter was sent, and so was confused by the notice of violation. And so the planning department highlights the language of the notice of appeal saying that it was incomplete when appellant stated that we want to ask for an extension as we have requested the tax clearance. We want to comply with all regulations to have our home properly operating. And when looking in the context of the fact that they had never received that denial letter, appellant was under the assumption that there was just a mix-up in their paperwork and they could clear it up with the planning department. But the bottom line is that that denial letter was never received. And so there was no opportunity to be heard on that. And then just 2 more points I'd just like to highlight from our motion for summary judgment is that setting aside the significant due process concerns, allowing the forfeiture of appellant's non-conforming use certificate does violate state statute and the Hawaii County Code because HRS 46-4 does state that a non-conforming use can only be eliminated if it's discontinued. And Hawaii County Code 24-4-61 is in accord, stating that non-conforming uses are allowed to continue unless that use ceases. And so to interpret the Hawaii County Code 25-4-16.1, which regulates non-conforming short-term vacation rentals as allowing the forfeiture for other reasons aside from that non-conforming use ceasing would be not in accord with the language of HRS 46-4. And here, as I mentioned, the undisputed facts support that appellant did have a non-conforming use. They submitted paperwork showing that the non-conforming use did continue. And it was just a matter of receiving that tax form to complete their renewal packet. But forfeiting a non-conforming use based on a single tax form would be contradictory to the language of the statute. And one final note is just that non-conforming uses, as we stated in our motion for summary judgment, are vested property rights protected by the United States and Hawaii constitutions, and must be, the Hawaii County Code must be interpreted as to not violate the constitutional provisions. So pursuant to those principles, appellant cannot lose a constitutionally protected vested property right that was properly registered and was not discontinued through a regulatory provision that requires this updating information to be submitted annually with the planning department. So I'll conclude because I know you have a busy schedule, but just to summarize, because there is a serious due process concern and because allowing the forfeiture of the non-conforming use when the use did not discontinue, for those reasons, we request that the board deny the planning department's motion to dismiss and grant the motion for summary judgment, which would require reinstating the non-conforming use certificate. So I thank you for your time. I think, Chair, you're on mute.
Oh, sorry. Thank you. Does the planning department have a response or anything further to say?
Nothing further. The planning department submits on its memo.
Do any members of the board have any questions? Mr. Wiseman.
Yes, and with respect to the merits of your claim with the planning use, although there may be merits there, I'm more concerned with the jurisdictional aspect. And as jurists, we all know that summary judgment is used when there's no material fact in dispute. And as a matter of law, you should get a judgment in your favor. However, according to my information, the second notice was received on March 9, 2022. And the appeal, or the notice of appeal, or the appeal wasn't granted until July 28th. That's untimely. We operate on whether or not we have jurisdiction depends on whether the statutory time for appeal has been complied with. And so how do you address that? Isn't that a material fact in dispute?
I believe that the appeal for the notice of violation was submitted within the 30-day time frame. There were some issues with the planning, as the planning department notes in its motion to dismiss, with the completeness of the notice of appeal, which is why they say it's untimely. But I believe the original notice was submitted within that 30-day time frame.
Well, again, it seems that this is disputed. Does counsel for the planning department have a response to that?
Yes, Commissioner. An incomplete application is not appropriately before the board in this case. The appellant has never filed a complete application. It is almost 2 years later, and we still do not have a complete application before the board.
Thank you. So, counsel, I'm sorry, I forget your name. What was it? Counsel for the petitioner.
Ms. Ziegler.
Okay.
Ziegler.
So you dispute that the March 9th notice of receipt of the NOV, you dispute that that should start the clock running. Is that right?
The notice of violation, correct, was received by appellant.
On March 9th.
I believe so. I think the notice of receipt is submitted. So.
Okay, well, let's assume it is correct, March 9th. That's the information, 2022. And then the appeal wasn't filed until sometime in July. So if those two facts exist, wouldn't that deprive us of jurisdiction, being after the 30 days being an untimely matter?
I apologize because I don't have let me just flip through, because I believe that the notice of appeal was filed within the 30 days of the receipt of the notice of violation. I believe what the planning department is arguing is that even though it was submitted within that 30 days, the notice of appeal was lacking some information that was requested.
All right, can I ask the planning department counsel? Is it your understanding that the appeal was filed untimely on July 28th?
Commissioner, it is our position that the appeal was filed untimely, also that it was incomplete.
All right.
Even at this point, it's still incomplete.
But as far as the filing requirement, that's where I'm focusing on, because we have the 30 days, which is jurisdictional. We don't have power to do anything if it's beyond if we don't have jurisdiction, and we don't have jurisdiction if it's beyond the time period allowed by rule or statute. So.
That is correct, Mr. Wiseman. The matter before us, first and foremost, is the matter of whether or not the appeal is filed timely, and if whatever the decision comes out of that is the next steps of whether they get a continued hearing beyond this.
Thank you. That's all I have. Thank you.
Sorry, I'd just like to clarify, there was an initial filing of the notice of appeal, and I'm just trying to find the date of that first filing, although I recognize that the planning department is arguing that it was incomplete. I just want to make sure that for the record, that first filing is noted. I'm sorry that I'm not finding that date.
Let me jump in. This is Deputy Corporation Counsel Cody Friend on behalf of the board. So I want to just correct one thing and make sure that Board Member Wiseman and the rest of my board members remember that we have two separate matters in this case that are in essence for the same issue. So Board Member Wiseman, in Planning BOA 2022-23, that is the initial filing that was done. At what Ms. Ziegler is trying to indicate is that it was the initial appeal was filed on March 31st, 2022. So within the 30-day time frame, that's what Ms. Ziegler is looking for. That was within the time frame. However, it was incomplete. Board of Appeals staff, as has been argued by the planning director, did communicate with the appellant to complete that. Under Board of Appeal Rule 2-4, subsection D, it does indicate that the effective date of the filing will be upon receipt of the corrected and completed document that has not occurred to date. So I think that's the confusion, and I just want to make sure my board members understand that we are dealing with two separate filings. So we have the initial filing where appellant did in fact submit his appeal within the required 30-day time frame, but it was incomplete. The appellant has failed to date to complete that petition or amend the petition prior to the hearing to complete it. So we have an incomplete petition in Planning BOA 2022-000023. Then on July 28th, 2022, in Planning BOA 2022-00029, we have the new petition for appeal filed. That is the complete petition done by Counsel Ziegler for appellant. So we have two, one that was done within the time frame that remains incomplete, and a complete one that was done on July 28th, so not within the 30-day requirement. So I just wanted to clarify, make sure that my board members were not confused as to the two matters. The motion to dismiss is as to both matters. I hope that helps everyone.
Thank you, Ms. Renz. As you were speaking, I found that March 31st date, so I really appreciate the clarification. So yes, the notice of the appeal for the notice of violation was submitted within the timeframe. But that notice of violation was issued based on the fact that the planning department had sent a denial letter that was never received by appellant.
And again, Cody, which case was filed timely? Was it 29 or 23?
23. 23 was filed timely, but remains incomplete to date. And under our current rules, Board of Appeal Rules 2-4, subsection D, once returns completed, that would be the effective date of receipt. That remains outstanding to date. So theoretically, if it were to be returned today, the effective date would be today, which would be outside of the 30 days. But that has not been done to date.
Oh, wait, I still need clarification. So the 29 was filed timely, the appeal.
No, 23 initial petition for appeal that remains incomplete, that was filed timely. The matter ending in 29 was done by Ms. Ziegler, and obviously as an attorney that was filed completely, but it was in July, at the end of July 28, 2022. So obviously outside of the 30 days. I believe their argument, Ms. Ziegler, is that the initial appeal that was filed was timely, albeit incomplete.
I see, thank you.
Do any of the other board members have any other questions? No further questions? With no further questions, can I get a motion on the department's motion to dismiss?
I have two motions.
Go ahead, Mr. Wiseman.
Yeah, I would make a motion to remand the case of 23. Let's just use the last two numbers to the department, since that appeal was filed timely, and allow that to be completed. And my second motion would be on 29, that it's untimely, and I would grant the motion to dismiss on 29. So it's a bifurcation.
So why don't we,
Yeah.
right, why don't we deal with the motion separately so that we keep a clean record? So let's first deal with Board Member Wiseman's motion to remand Planning BOA 2022-000023. The only way that would pass is if we have a second and following discussion, there are enough votes. Otherwise, if it doesn't pass, we will move on to your second motion and see if we have another motion as to the matter ending in 23. Is there a second as to Board Member Wiseman's motion to remand the 23 matter?
Board Member Henderson, I second his motion to remand.
Thank you. Is there any, I open the floor for discussion
Yes.
by board members.
And may I?
Go ahead, Mr. Wiseman, and then I have Ms. Ike.
There's a substantial rights here. People make investments, and when they came out with the short-term vacation rentals 2-3 years ago, this put a tremendous burden on all the vacation rentals, and perhaps there's a lot of good benefits that come from that law, but at the same time, it did affect property rights of others. And I think someone should be, if it's a technicality, like an incomplete application, if the appeal is filed within time, it gives us jurisdiction. I think we have the discretion to remand it to the department to follow up on that and give that person a chance to complete it. So, thank you.
Thank you. I think I saw a hand from Ms. Saiki. If you want to unmute.
Thank you, Mr. Wiseman. I understand what you're saying. What I wanted to question is the combination. When we combine both appeals, petitions, well, how much weight, can we separate it? and deal with it separately right now? Or is it together that we have to determine?
I'll defer to legal
No.
counsel on that.
We are separating it. Our first discussion is on 00023 and Mr. Wiseman's motion to remand and Mr. Henderson's second of that motion. So that is the case in discussion at this time. Any other questions, Ms. Psyche?
I'm done. Thank you.
Board Member Henderson,
Mr. Henderson?
if these two separate appeals are consolidated, does that affect the documents and their timely receipt or not?
No.
I will respond, Vice Chair Henderson. This is Cody Friends, Deputy Corporation Counsel. So we consolidated them for efficiency purposes. What that does not mean is Ms. Ziegler's untimely appeal in 29 doesn't mean that we can use the incomplete petition filing date to somehow mean that they're on time in the newer matter. It just means that they're both raising the same issue by the county, right, the planning department. So let's hear both motions at the same time, so we don't do one motion and right after that we call the other matter and we do the exact same motion. So it was solely for that purpose.
Any further questions from the board on case 2022-0023? Seeing none, we can call for a vote. Motion to remand to the
Case number 23.
case number
Okay,
23.
the motion to remand back to the department for case number 23. Mr. Wiseman,
Yes.
Mr. Henderson,
Yes.
Mr. Davis,
Yes.
Ms. Psyche,
Yes.
and Chair Aguiar.
Yes,
Okay, motion passes.
thank you. So moving on to the second case, 00029, can I, Mr. Wiseman, I think already made a motion to.
Yes. Yes, I would
So-
grant the, would you like me to repeat it?
Yes,
Yes.
please.
Okay. Yeah, I would make a motion on the other one, 29, ending in 29. I would make a motion to grant the department's motion to dismiss based on his untimely, under the rules, under the 30 days. They didn't comply with the 30-day requirement. Hence, we don't have jurisdiction.
I
Is
second.
there a second? Thank you, Ms. Psyche. Any discussion on the matter? Seeing none, let's take a vote.
Okay, motion to grant the motion to dismiss for case number 29. Mr. Wiseman,
Yes.
Ms. Psyche,
Yes.
Mr. Davis,
Yes.
Mr. Henderson,
Yes.
Chair Aguiar,
Yes,
motion passes.
so me? Okay, go ahead. Thank you.
Okay, so given that the motion has passed, Ms. Tiapula as the prevailing party as to 29, we'll ask you to prepare a form of the order granting the department's motion to dismiss the 29 matter, provide that to Ms. Ziegler. Ms. Ziegler, you are free to object to the proposed order, and or if you could stipulate and expedite that process, that would be great. Ms. Ziegler, as to the matter in ending 23 as the prevailing party in essence, please prepare a order remanding that matter to the planning director to complete the process there as they see fit. Council, any concerns with what I've indicated?
No concerns.
No.
No concerns for me.
Okay, so council, if you could please prepare those forms of the orders, provide them to the Board of Appeals and opposing counsel within 14 days of today.
Yes.
All right, great. That concludes all of the matters ending in 23 and 29. We will, you are free to join us on the YouTube link if you want to continue. Otherwise, Ms. Ziegler, have a great day. And thank you, Ms. Teopula, as well.
Thank you.
Thank you very much for you guys' time.
Thank you. So I think we are going to try and jump back to old business and see if Mr. Myers and his land planner, we can. Okay. Actually, so Mr. Henderson, since you're still with us, we can move on to new business item number 2 and continue hearing that case while you're still on Zoom with us.
Okay, doke.
Are you ready? Okay. Can I introduce the case while you're letting everyone in? So I will do that. Introducing the case we're about to hear, item number 2 on the agenda, Crystal Yamamoto, PLBOA 2021-00004, appeal of decision by the planning director dated August 17th, 2021, regarding variance from Chapter 25, zoning, Article 5, Division 3, Section 25-4-44, permitted projections into yards and open space requirements, VAR 21-000628, location, Waikea Cane Lot, South Hilo, Hawaii, 96720, TMK 3-2-4-017-017-0000. April, are there any public testifiers on this agenda item?
No, Chair, there are no testifiers.
Can I get the names and appearances of the parties for this matter, starting with the appellant, please? Is Ms. Yamamoto on? Oh, I see Ms.
Hang on, Chair,
Yamamoto.
sorry.
Oh,
Hang on, Chair.
hi, Ms. Yamamoto.
These are testifiers.
Hold on 1 second. We're looking if we have any public testifiers.
So, Chair, we need to ask if Sony Coco and Wilford
Komine.
yes, and Keiko Bonk, if they are testifiers.
Can I, if I have Keiko Bonk, Wilford Komine, or Sunny Coco on as testifiers, can you acknowledge and activate your camera as well?
And if they are.
Yeah, I'm on.
Can I, if I have Keiko Bonk, Wilford Komine, or Sunny Coco on as testifiers?
That's the YouTube live. Yeah.
Oh, how come?
1 moment, everyone.
YouTube. I muted him.
Oh,
Somebody-
okay,
was
got
coming
it.
through someone else.
Ms. Yamamoto,
Yes.
Ms. Bonk is your witness today? Or a public
Yeah, so
testifier?
Keiko Bonk and Willie Komine are 2 of my witnesses in the hearing today. I also have
Captain Henderson,
2 other
witness
witnesses
today? Or a public
Yeah, so
testifier?
Keiko.
Hello?
Okay, so we're getting feedback because hold on, hang on one, sorry. I think Mr. Comine, it might be you. If I'm wrong, I apologize, but someone's running the YouTube live streaming in the background.
Yeah,
Please
so
turn that.
Hiko,
Oh, I got off that. Hello?
Thank you. Okay, so we're getting feedback because hold on, hang on one, sorry. I think Mr. Comine, it might be you. If I'm wrong, I apologize, but someone's running the YouTube.
Excuse me, in view of the technical matters we have to deal with, can we have a 5-minute break while it's being dealt with?
Sure, we'll take a recess in place.
So
We'll see everyone at 10:36. Crystal, if you can work with your.
if you want to stay on to resolve your technical matters and tests, that would be great.
okay, sure.
If we can test, so Crystal, you're sounding fine. Ms. Bonk,
Hello?
can you speak?
Yes.
That sounds good. And Mr. Comine, can you unmute and speak?
Okay, we lost him.
Can you hear me now?
Oh, yeah, we got you, Willie.
Okay, so I'm having problems with the video. I'm not sure.
Did you hit the video turn on? You hit the unmute. The one next to it is for video.
I hit the unmute.
And right next door it says
there's like
a
three.
Has a camera.
No, I don't have that. I have a start video. But I
Yeah,
don't have.
that's what. Yeah, start video. Start your video.
Okay, I thought.
There
My
you are.
mistake, sorry. I thought start video meant start video recording. So
No, that's you. There you are.
okay, sorry.
No
I'm not
problem.
doing that.
It's been happening all day. It's okay.
So we are in a
Thank you.
little break at this time.
Oh, break. I think I might take. Can I disappear for 1 second?
You can. We'll be back in 3 minutes.
Okay, perfect.
Well, I'm here. Are we back on yet?
Not quite, Member Wiseman. We're trying to get Ms. Rohr connected. One moment, I'm sorry, sir. She's commenting on the chat in the YouTube video.
And we're back. So we're back off a break, thank you. I believe we identified that we have no public testifiers at this time. Moving forward, can I get the names and appearances of the parties for this matter, starting with the appellant and, oh, I'm sorry. My apologies.
Yeah.
We do have no public testifiers, so let's proceed with our hearing. I'd like both sides to know that we have read the record in this case, and with that in mind, please do not repeat what you have already provided us. Know that we have read it. If either side begins to present testimony or evidence that is not relevant to our hearing today, you may be interrupted and stopped. There is one legal issue before the board, whether the director's decision in question should be reversed or affirmed. With that, let's begin. Ms. Yamamoto, will you be testifying yourself?
Hi there, Chair Aguiar. I will be making a statement, and I am my own representation during this hearing, so I'll be kind of talking throughout my time here today.
Great. So being a pro se and being your own witness, if I can swear you in, do you swear to tell the truth on matters before the Board of Appeals today?
Yes, I do.
If you'd like to call your first witness or testify yourself, I will be swearing in each witness as you call them to testify as well.
Okay, sounds good. I'll go ahead with my opening statement and then I will start calling my witnesses.
Thank you.
Okay. Aloha, Chair Aguiar and members of the board. Thank you for your time. My name is Crystal Ann Shizuko Yamamoto. I am the appellant in this case. I am appealing the planning director's approval of variance 21-000-628, which permits setback variances for proposed construction of 8 two-story duplexes on approximately half an acre of land along a private driveway that my neighbor Keiko Bonk and I share. First of all, I would like to share with you why I'm speaking before you today. 231 C West Lani Kaula Street is my home. I was born and raised in Hilo by my grandparents, James Hideo Kato and Shizuko Ochiai Kato, within the old plantation house at this address since my birth. I played with my neighborhood friends along our private driveway. I rode my bike up and down more times than I can remember. And I came home for dinner when I saw the yellow glow from the lights on Lani Kaula. Easter egg hunts with my neighborhood friends and the excitement of staying up late during New Year's were the more celebrated memories of my childhood. But my grandfather balancing me in his wheelbarrow when doing daily yard work, and my grandma and I building little houses out of sticks and opihi shells in the backyard stands out in my memory. I am grounded in this land. My great-great-grandparents, Satoru and Suneyo Ochiai, who owned a large portion of Waikiakine lots, had the foresight to know what I experienced as a child, open space and a sense of community. This is something they wanted to perpetuate. It was their intent to maintain this way of life. Thus, they subdivided their land into 5 smaller lots to encourage single-family homes and a mixed-use development of our neighborhood. The lot of proposed construction is actually 2 of the 5 individual lots that landowner Ms. Coco purchased together. My fellow neighbors and I have longstanding roots in the West Lani Kaula neighborhood and are jointly opposed to Planning Director Zendo Kern's approval of variance 21-00068. At this time, I would like to call my neighbor and witness Keiko Bonk to share her testimony against the Planning Director's decision.
Keiko Bonk, Ms. Bonk, do you swear to tell the truth on matters before the Board of Appeals today? And you have to unmute yourself.
Sorry, I do. I'm unmuted.
Thank you.
Ready? Aloha, Chair Stacy Aguiar and fellow board members. My name is Keiko Bonk, and I'm the owner of the property directly adjacent to Miss Sunny Coco's property, the person who's requesting a special variance for the setback laws on our private driveway near Lani Kaula Street. Ms. Coco recently purchased an extremely, mind you, narrow sliver of unmanaged property next to my home on a jointly owned private, most of my life, dirt driveway. I and my fellow neighbors own similar single home land, little parcels on this little driveway. And we are all already starting to be negatively impacted by Ms. Coco's actions. I recognize that the landowner, a landowner in general, has a right to build on their land. This is not the problem. All of us, however, on this little strip of land, built our homes in the late 1950s, 6 decades ago, and we bought to enjoy living in a neighborhood that was on a private rural driveway. We also hoped we would enjoy the company of other neighbors on these small parcels, and on particularly the last of the unmanaged parcels, that the one that Ms. Coco recently built. Now, there have been other developers in the past that have come to this parcel with maybe an idea to build a larger development. Billy Kimi, who many of you know as a pillar businessman of our community, once bought this land and came to the county for a request for a variance. He was denied the variance, and he decided logically that it probably was a small parcel and that his project in mind would do well elsewhere. I think the biggest problem we have here right now is that the planning department did not come to take a look at the site at all. I was told this by the planner. And what Ms. Coco is trying to do on paper is really due a fast turnaround of a small sliver of land to increase her profits. Miss Coco, and I might interject a little metaphor, is reminiscent of the greedy stepsisters in the fable Cinderella. They were so determined to squeeze their larger feet into a small, delicate glass shoe that they almost created a mess by breaking the shoe. This land is such a sliver, it's almost a joke and an absurdity to think that someone could build 16 home units with 32 car lots. I think it's in the best interest that we stop before the shoe breaks. And in planning terms, we stop before more ill impacts and infrastructure problems take place in our neighborhood. If the County of Hawaii planners would do actual site visits when they are not familiar with neighborhoods variances are requested, or perhaps if they would talk to the neighboring residents, like Crystal and myself, these planners might therefore become familiar with variance impacts. They could learn firsthand the ins and outs of the place where the actual people live, and they could learn about infrastructure needs and patterns of traffic. And planners may also come to learn to make better recommendations for our community. And they may even come to similar conclusions as the residents who live and have lived for a long time on this small driveway in Hilo. It is irresponsible for the county planner to rubber stamp variances without investigating the financial and physical impacts of the existing neighborhood residents. I note right here that Zendo Kern had listed one of his reasonings that there would be no impacts, adverse impacts to the residents neighboring this proposed variance. This is false, absolutely false. This variance seems very suspicious to all of us in the neighborhood. It seems that Mr. Kern rationalized it as a personal financial favor given to a friend with no concern for the real impacts on public infrastructure development and services and quality of life and financial interest, I might remind you, of myself and Crystal and the neighboring landowners. It is the public's official duty to uphold good planning laws and guidelines for building, and to eliminate favoritism and graft in this process. This speculator proposes to build 2-story 16 homes and 32 parking units on a sliver of land. And the only reason I heard from the planning director is that she bought a small piece of land and her project needs more space to make her more money. Her project doesn't fit the land. This is what he told us. Well, in this case, a logical planner would highly recommend that this landowner probably needs to buy a bigger piece of land. The lead planner's job is to consider the general public's best interest. The public planner's job is not to increase one person's profits for one person's business while decreasing the quality of life and well-being of all surrounding neighbors and dismissing good, well thought out public policy like our Hawaii setback laws. Ms. Coco's proposed project, I'm sorry, Ms. Coco.
I'm sorry to interrupt you, but I will give you 1 more minute to complete your testimony.
I didn't know we had a time restriction as witnesses.
You,
I know public.
You do not, but we did read your written statement and all of the
I never
documents.
sent in this written statement. I'm reading it. I'm speaking to you today because I've never had an opportunity. The director didn't give us real opportunities to lay a case, or the planners didn't come to our site. I think it's the least you can do because the rationale was, I was put in the rationale. I am the next door neighbor. He said I would not be impacted. this is false. So I'm the witness saying that is not a true, that's a falsity. So if I'm accusing the director of actually making a public determination based on a falsity, I think it would be to the best interest of all the Board of Appeals to allow me to continue, because the logic needs to be continued in order to understand the falsity. So Ms. Coco's proposed project is the exact reason why setback laws were established. We who work in public policy for land use development, I have experience. Yes?
Yes. I understand you are presenting your position. However, we can't have a unlimited time period. There has to be.
Oh, I won't. I have an end. I do have an end, and I have suggestions. I'll fast track and cut out some of the things if they're redundant. But the very reason we have set up setback laws are so that everyone shares in the responsibility of open space. Now, we know that, and if we don't adhere to this, we are going to make the big boo-boos of the past leaders in our community to have development go amok and eventually pave over all space that creates greenery and creates flooding mitigation and creates areas for people to relax and play and for people to gather and, so forth and so on. We need to uphold our laws. Now, here is the most absurd part of this. We, Crystal and I, you have to visualize this because we were told by the planning department, they never went to the site, so they couldn't even imagine it unless they go there. They did this based on paper that they saw and somebody driving around looking at the Kushi development and the other one, which this is nothing like because it's on a private driveway and it has no main arteries of Ululani Street or Kapiolani. So it's not comparable. It's a private driveway that has been residential. If you build 32 cars alone on Miss Coco's property, Crystal and I have a larger property. We can come into you guys and say, hey, can we have a variance for 32 more cars? You set precedent. Are you going to deny us for the same reasons? Our financial need? Oh, we want, there's no mitigation. Our neighbor, he has a little larger lot. He can have 48 cars based on the scale that you allowed her. And the front house can have 16 more because they have a smaller unit, half the size of mine and Crystal's combined. Add that up. That's 128 cars. 128 cars, parking only, no visitors, no services coming in and out. 128 cars on a driveway, not a road, a driveway. Very private, we own it, driveway, skinny, narrow. Hitting on Lanikaula, what? The newly created intersection on Kapiolani and Lanikaula to mitigate traffic that has been increasing for the expansion of the University of Hawaii and needed expansion of Kapiolani for more arteries in Hilo town. What a mess. Already, since that road has been created, that little stop there with the two traffic lights, with the four-way stop, when you go out, as someone who's lived here 63 years, you can barely get out on midday because of the traffic. You put in 128. Now that's what this decision of Zendo fairly mandates to all of us on this strip. We could have 128 parking stalls here. It's a parking lot, by the way. There would be hardly any room for anybody to do anything at this point. And you've created a massive traffic cluster mess gone amok. Now, with all other reasons for public setback laws, the same kind of multiple things happen. And you have to multiply them by all these other people that own land on this strip. So you're getting the picture. I grew up on this road, just like Crystal, but a generation before. And, you know, like Crystal, I played in this area and it was a very safe neighborhood and it was very charming. And I've already recognized how much of the charm of Hilo we've lost. And my parents, this woman has been rationalizing, oh, she knows the University of Hawaii. She doesn't even know it. She lives in Honolulu. My father was one of the 10, eventually 11 professors that started at the University of Hawaii. My mother was an educator. They dedicated their life to Hilo and to a vision of a University of Hawaii Hilo college town. That vision has really been lost. This road served real people at the University of Hawaii for decades. It was a real functioning community. Mr. Kato was also an educator, a principal in the DOE system. Mrs. Kato worked at the Hilo High School. She was in education. My mother worked in education in the DOE. She even worked with very hard students, potential dropouts, and gave them a good life because she changed their lives. These are real people. Miss Coco has no concern for these real people. She blew us off 2 times. She downed trees on my property and she never had the courtesy to come and say, I'm sorry. And she never paid back for the damages. She doesn't care about meeting with Crystal, myself, or Willie. She blew us off in a meeting she set up. We waited 1 hour for her. That is neighborliness. She has none. So if you're asking me to shorten this, I will tell you that this is a big, big mistake and it can get out of hand because as a planner, and as someone who knows that small, consistent, good laws like setback laws that I help work on, access laws, setback laws, anything that protects the slivers of open space that we can have in Hawaii, they should be guarded with our lives because everybody wants a piece of the pie in Hawaii. And eventually the piece of the pies are going to get smaller and smaller and you're going to have less open space. And this woman is trying to create a monster. All you have to do is drive down that little strip and you would agree with us. I don't know anybody that I've told about this project that didn't agree. In fact, so much so that one of the outstanding members of our community who is actually building housing on public lands for veterans and for elderly people, right near us, we're not protesting that project. He has been working on this project with everyone in the community. He asked me to interject with his ideas because he was late for the public testimony, but his name is Bob Williams. You might know him. He and his friends, he's a vet himself, have been working on a veterans housing project, large one. And they have been working together with the community. They oppose this project as well, and they oppose the setback variance that you gave to this developer.
Ms. Keiko, we did.
Can I read this into the record?
We did. Ms. Bonk.
Did you get this?
His written testimony was given to the board and we did receive it and it is part of the record.
Oh, okay, because we were told it didn't make it in. And that's the only reason I was trying to interject right now. I'm sorry. But so you can see that there is a unified agreement amongst our not witnesses, but neighbors in this neighborhood, including the apartment owners on both sides of our little neighborhood alley, who agree that the open space that even we produce is necessary for their enjoyment as well. And I close on that.
Thank you. Does the planning department have a cross for Ms. Bonk as a witness?
Good morning, Chair and board members. Jean Campbell, Deputy Corporation Counsel for the Planning Department. No, we don't have any questions for Ms. Bonk. Thank you.
Thank you. Are there any questions by the board for Ms. Bonk?
Yes. Ms. Bonk, I understand you were on the planning commission at one time. Is that right?
No, my father was on the planning commission. I was a Hawaii County Council member for, and I worked on public policy for a long time.
Was there a Hawaii County plan for that particular neighborhood at all?
Well, it's part of the general plan. And for years and years, the University of Hawaii, including my father, had worked in the community with various leaders, various mayors, various county council members and planners to try and draft a special design district for the university. And I think it would be really beneficial to have something like that, but they could never, at the time he was sort of working, it wasn't known that this would be a logical thing to do for a future.
Thank you.
thing.
And
Yeah.
one other thing, on several of your exhibits, you have a tape measure or some other measure showing a distance
Yes, Crystal Yamamoto is going to actually explain all that to you.
on the private road. Is that the setback distance that it shows?
No, actually, that's the size of the road.
Well, I saw
That
the
goes-
road, yeah.
Yeah.
I see the road, and then I see a tape measure that go.
Yeah.
Can
Crystal's
I-
going to explain that to you.
Yeah, so those are actually my exhibits, and I'll explain them a little further along.
Well, just that one question.
Yeah,
Does that,
Crystal, explain that.
will you lay out the yellow tape?
The yellow tape measure, yeah. So what I'm trying to demonstrate there is the private driveway currently there's two lines of asphalt for the tires for the width of a car, a single car. And based on the TMK and our deeds, the actual width of the private driveway is actually 18 feet, 18. So what the tape measure is representing is the additional 11 feet to the 7 feet of the asphalt. That would be the total width of the actual driveway.
Yeah. And Ms. Monk, one thing, there was never you were never contacted to give any input or public hearing or anything?
No, no public hearing. No, we pursued meetings with Director Kern, and we pursued meetings with the developer, but pretty much it was fast tracked and we got blown up.
Okay.
So, it became pretty apparent to me that it was some favor or something like that. It wasn't
Thank
really.
you. That's all I have. Thank you. Thank you, Chair.
Thank you. Ms. Yamamoto, do you have another witness you'd like to call?
Yes, I do. So at this time, I'd like to call my neighbor and witness, Willie Komine, to share his testimony against the planning director's decision.
Thank you. Mr. Komine, do you swear to tell the truth on matters before the Board of Appeals today? And you have to unmute yourself.
Okay, can you hear me now?
I can. So let me swear you in again. Do you swear to tell the truth on matters before the Board of Appeals today?
Yes.
Please proceed.
Good morning, everyone. My name is Willie O'Wolford Komine, and my property borders Keiko Banks on the other side. I just wanted to share some of my thoughts on this project. It's more in a set of questions. For example, like, what are the benefits, if any, would it have on the established neighborhood? Wouldn't this project only increase the population density, increase congestion, noise, and in general affect the quality of life of its neighbors? It seems to me a lot of more traffic congestion will be created, that is, entering and exiting their lots onto Lanikola Street. Making a left turn into the private road from Lanikola Street would become an issue, especially when the university is in session. To me, the director similarly granted a variance that will reduce the county setback requirements when apparently there was no traffic, sewer, and utility studies or analysis done to support his decision. Is this the norm? Shouldn't a preliminary or at least a cursory analysis be accomplished first to ensure the project, which will consist of 16 units with 32 parking spaces, is good to go. In closing, I urge you guys to reconsider overturning this ruling unless the applicants do their due diligence, that is, pre-development groundwork. But to me, more importantly, I believe acquiring community support is critical. Having a social, like a town meeting with the neighborhood people and listening to their concerns is a great start. Perhaps a compromise of what is reasonable to build on this small strip of land could then be achieved and agreed to by all parties rather than taking a unilateral approach and trying to maximize the number of units by using a variance. Thank you.
Thank you, Mr. Komine. Does the planning department have a cross for this witness?
Good morning again, Jean Campbell, Deputy Corporation Counsel for the Planning Department. We have no questions for Mr. Komine. Thank you.
Thank you. Ms. Yamamoto, do you want to call your next witness, if any?
Actually, I don't have any more witnesses at this time. I just want to make a couple comments and speak a little bit before calling my next witness, if I'm able.
Hang on, Ms. Yamamoto, I think our board member Wiseman, you have a question for
Yes,
Mr.
for the
Komine?
last witness, Mr. Komine. Were you ever contacted by the planning department about this setback?
No.
Were you ever invited to attend any presentation of it?
Presentation.
Well, in other words, their plan, what they were going to do. Were you ever invited to view this?
No.
Offer any comments on it?
No.
Thank you. And it's part of the setback. Well, are you a partial owner of that private road?
No, I'm on the other side on
I see.
Ulani,
Okay, thank you.
bordering Keiko Bunks.
Thank you. Thank you,
Okay.
Chair.
There is one matter on this case that I did not get clarification on, and if I may ask this of our board support. April, can you verify that the appellant provided notice of today's hearing to surrounding property owners in accordance with BOA Rules 8-11D and has filed with the board proof of service of the hearing on the property owners within 300 feet? Question is for April. And
we do have proof of service that was received on August 27th.
Thank you. So we can continue on with our hearing. And Crystal, if you have an additional witness you want to introduce?
Yeah, sure. I just want to kind of segue to that witness. So I just want to make a couple comments before I call them, if that's okay.
Yes, go ahead.
So, at this time, I just want to, I'd like to reference a signed petition against the planning director's decision signed by two neighbors that could not be present today. I do have that in my exhibits. I can pull it up if you would like me to share my screen. Wait 1 second. Are you folks able to see my screen, my desktop? Are you able to see my screen, Chair Aguiar and board members?
Yes.
Okay, beautiful. I just wanted to share this. So it's just a petition that I had drafted, basically against the approval of the variance 21000628. I just wanted to acknowledge that, and reiterate that we do have a, kind of a community neighborhood support against this variance. This petition was signed by Ms. Ada Hayashi and Ms. Lauren Inaba, who are a part of our La'ikaula neighborhood.
Great, thank you.
Thank you. I'm going to stop sharing my screen now, and I'm going to go back to making comments. Okay. I'd like to also mention that my neighbor, Winfield D. Madden, he's the owner of Hawaiian View Properties, LLC, which manages University Palms, the apartment complex for students off of Kapiolani Street, below the UHH. He is also, against the planning director's decision. I had a personal conversation with him, and he couldn't be present today, but I just wanted to make that known that he also does not agree with the variance approval. A question for the board. Did the board receive a public letter of testimony from Mr. Madden?
Let us check.
We have some late testimony from A. Williams, but we do not have anything, Ms. Yamamoto, by the name that you indicated.
Okay, thank you so much for checking. I
We
appreciate
also have some late testimony, of course, sorry. We also have some late testimony that I will address once we get to the department's case from Sunny Coco, excuse me, but I'll address that later. Go ahead.
Okay, perfect. So moving on, I just want to make a point that's on page 50 of on the record on appeal. The site plan refers to the our private driveway as a roadway. I just want to make a note that this was what the planning department saw. Our private driveway labeled as a roadway. I just want to acknowledge that this is misleading. It should have been labeled driveway, maybe private driveway. Looking at definitions, chapter 22, county streets, article 1, section 22. 1.2 states a roadway means a portion of a county street, excluding shoulders, curbs, gutters, sidewalks, or other roadside drainage facilities used exclusively by vehicular traffic. And driveway means a road on private or public property giving access from a private or public street to an established use on the property. I just, going through the record on appeal, I really wanted to point that out. I think that's really a key thing to realize. At this time, I'd like to call Larry Nakayama, planner assigned to the variance request, as a witness.
Is Mr. Nakayama here?
Morning, everyone. Mr. Nakayama is here with us, and we are getting our camera turned on and focused on him. Give us 1 minute. Thank you.
Okay. Are we good to go?
Good morning, Mr. Nakayama. Do you swear to tell the truth on matters before the Board of Appeals today?
I beg your pardon, Beth.
Do you swear to tell the truth on matters before the Board of Appeals this morning?
Yes, I do.
Then you can proceed with your testimony.
Mr. Nakayama, I just have a couple questions for you. One, did you visit the project site prior to submitting the variance for approval?
Yes, I did.
I'm sorry?
Yes, I did.
Okay. To clarify, you actually drove up the private driveway.
The gravel driveway. The gravel driveway, the rocky roadway. Yes, the roadway, yes.
Now I know that Keiko Bonk had testified before you, and she did mention that you folks had a conversation. She mentioned that you did not actually visit the site plan. Is that correct?
I don't recall that. I don't think we had a discussion as to whether we did a site plan or not.
Okay, but it is your testimony that you actually went to the,
Yes, ma'am.
okay. And it was based on the visitation and your experience as a planner, you thought that in your professional opinion, this project or this variance would have been an okay thing to submit for approval?
Yes, because the property is already zoned for it. It's zoned RM1. So
okay.
It allows for the apartment. It allows for a 23-unit apartment. And also, it's like I said, it's already zoned. Federal plan has it as a high density urban. So it falls within the criteria.
Okay. So just to reiterate what you have said, a large part of your decision to submit the variance for approval, it was based on the zoning, the RM1 designation. Is that correct?
Yes, it's all for RM1, ultimate residential, 1,000 square feet.
Okay. And you didn't think that the space, the narrow lot itself was a problem for such a large scale project?
No, it could be worked out in later on as when they come in for the building permit plans.
Later on. So that being said, you were aware that it was a private driveway, not a county roadway, right, to access the property?
It's not a private driveway, it's a private roadway.
So I think, so again, going back to the definitions, roadway, county street, driveway, road on private or public property giving access to and from adjoining properties. So I think there's a little bit of a kind of a definition clarification there, but that road to access the lot in question is not a paved county road.
It's not, it is a private roadway.
Private driveway, but not a county road.
Private roadway.
Okay, I guess we'll have to agree to disagree. That's all the questions I'd like to ask Mr. Nakayama at this time.
Thank you.
Hold on, Larry. I think you have a question from a board member. Have a seat. Chair, you're muted.
I apologize. Does the planning department have a cross for Mr. Nakayama?
Thank you. Jean Campbell, Deputy Corporation Counsel. No, we have no questions for Mr. Nakayama.
And for the board, does the board have any questions for Mr. Nakayama? Mr. Wiseman? Oh, I'm sorry.
Chair Henderson was.
Let's start with Vice Chair Henderson.
Thank you, Chair Aguiar. In the matter of the roadway that Mr. Nakayama is talking about, I think that if Ms. Yamamoto would look at the deed on the properties, it refers to that easement as a roadway. So you can call it a driveway, but for all intent and purposes, it is a roadway.
Thank you. Mr. Wiseman.
Yeah, you mentioned that the zoning permitted this type of development there. But let me ask you something. Could it have been done without? Could it be done without the setback of a private property?
Because of the nature of the property and long and narrow, they could have done a much higher building, or they're allowed 120 feet height limit in the zoning. so they could go up, but to keep in character with the two-story apartments in the area, it was decided that it would be best to keep it in the two-story, because they're allowed to go up to 120 feet.
But when you say if decided it would be best for the developer, not anyone else.
To keep in character with the surrounding properties, as there are other apartment buildings in the area, which are two-story in height. They could technically go up to 120 feet in height if they wanted to.
Thank you. That's all I have.
Thank you. Are there any other questions by the board? Seeing none. Ms. Yamamoto, do you have any other witnesses?
You're muted.
Sorry, my apologies. I do have a couple other witnesses that will be making really brief statements, but I just wanted to take this time to share some pictures of the site and a video as well, so that the board can see, what the site looks like, how small it actually is. So I'd like to do that at this time. Oh.
Are these pictures, Crystal, that were part of your appeal package and the video that was already included in our package?
Yes.
So we did review all of them.
Oh, okay. I wasn't sure if I had to, go like guide us through it. Actually, I do have a couple comments though to make on the pictures. Like I know you saw them, but I wanted to like refer to them and just kind of make some comments.
Got it.
Okay,
Just going to interrupt briefly, Crystal or Ms. Yamamoto.
Yeah.
Why don't you do that in your presentation, ma'am, when you've been sworn in, just to keep the flow of the appropriate flow of our meeting. If you want to testify and or reference any of your exhibits, you can do that when you testify specifically. So why don't we continue with your witnesses? And when those are done, then you testify and do all of that, ma'am.
Oh, okay. Okay, sure. So I guess I'll go to my witnesses, get that done to go with the flow. I do want to segue back again with the exhibits, and then there's also a kind of, I want to address the planning director's grounds for his grounds for the variance approval too. Can I make comments at that time with the exhibits on that altogether?
You are free to make comments about anything and everything you think this board needs to hear when you speak. So right now, just present your witnesses, and then you are free to comment regardless of where and when. Yes. Next witness.
Okay. Got it. Okay. So I'm just gonna make a quick point so that I can segue to those witnesses so that there's context. So I want to mention, there have been no traffic, fire, sewage studies that have been done. Department of Fire, Department of Public Works Building Division, Department of Environmental Management Wastewater Division were not aware of the proposed construction. And this is because no applications along with construction plans were submitted for permitting. Department of Public Works Engineering Division, although aware of the proposed construction, have not commented because they have also not received construction engineering plans. Based on this, I really do think that the planning director's approval of this variance was premature. A project of this scale on such a small parcel of land, I believe that comments are imperative from each department, and these comments should have been thoroughly considered prior to the planning director making an informed decision. That being said, I would like to call Captain Roy Henderson, Fire Prevention Captain, as a witness.
Is Mr. Henderson?
Yes.
Yes, I'm on.
Captain Henderson, do you swear to tell the truth on matters before the Board of Appeals today?
Yes.
Crystal, you can have your witness.
Hi, Captain Henderson.
Hello, how are you? Good.
Good. Nice to see you again. Thank you for being present. Hey, I just yeah, so I just wanted to ask you a quick question. Were you or the fire department aware of the proposed construction prior to me bringing it to your attention?
No, we were not.
Right, and this was because the landowner did not apply for a permit, and thus you could not make any comments on the project because you had no knowledge of it. Is that correct?
That is correct, but there's a process that is required. So planning's process comes before the building permit process. So typically on a construction, if it's a major, and I mean major, being a mall, something like that, we would get an opportunity for comments. But in this case, with duplexes, the fire department typically would not get an opportunity to look at it before the building permit process. So the building permit process comes, we look at what they propose, and then we give them comments. Yes.
Understood. I just wanted to acknowledge that you were not aware of the project at this time, or until I brought it up to your attention.
Yes.
All right. Okay. That's all I needed to ask. Thank you for your time, Captain. I really appreciate it.
No problem.
Have a good day.
No problem. Yeah.
Thank you. Does the planning department have any questions for Captain Henderson?
Morning again, Jean Campbell. No questions from the planning department for Captain Henderson. Thank you.
Thank you. Do any of our board members have any questions for Captain Henderson? Mr. Wiseman. You have to unmute. Thank you. Oh, he's still on mute.
Hang on, David, we still can't hear you.
Yeah,
Oh,
Captain,
you're
sorry. Are you familiar with the proposed project area?
At this current point?
Yes.
Sir, I've only received word from the appellants. I have not received any sort of plan, sketches, anything like that this time.
I see. But in your experience, a proposed project on a small private road, that would, how does the fire department treat that as far as responding to any emergency?
Well, it depends. Like I said, every project has its challenges and nuances, right? So when they're coming in for building permits is when we get to look at the project, building size, setbacks, if there's water, where the hydrant is. So that's the time in which we make our comments and assure that things are correct. Yeah, we don't, because in the planning stages, a lot of things can change within the application from planning to the actual building permit itself. So because those changes happen, we can't say, one or the other.
Do you know if there's a fire hydrant on that street?
Like I said, sir, at this current time, I've been given no sketches, drawings. I know there's a fire hydrant there. I tested one myself, but like I said, in terms of where it is, how far it is from the property, with those things we give our comments within the building permit process.
And one more question. Do private roadways also maintain the blue marker that goes in the center of the road for a fire hydrant?
So those are markers that we place on the roads.
Yeah.
We do them so that when we're responding to a fire, the driver of the engine can see that there's a blue marker there indicating a hydrant. Yeah, because sometimes obviously some hydrants are hidden between shrubbery, bushes, overgrown stuff.
That's a national practice too, right?
Yeah. So we attempt in our best to do our own due diligence where new hydrants are placed.
Thank you, Captain. That's all I have. Thank you, Chair.
No problem.
Thank you. Thank you, Captain Henderson. Crystal, do you have any other? Oh, I'm sorry. We may have one more question from a board member for Captain Henderson, Mr. Davis.
Oh, no problem.
I just wanted to, it's a little bit of I wanted to kind of make a little bit more of a statement, or actually talk to Ms. Yamamoto briefly. I've worked with Roy on some things in the past, but there is a long, as Roy mentioned, there is a long and arduous process. Approving the zoning and the setback is the only question in mind right now. That is all. And after that, you have 5, 6, 7 different departments that this is going to have to go to. Just like Billy Kinney looked at this property and made the decision that the investment was not worth the return. There is there's a big, long process, and fire is the last one to get in there and really looks at safety and how they get their trucks in and out and all that kind of stuff. So I guess what I'm saying is that we're looking at the setback variance. That is the only thing that is on the topic here for the Board of Appeals. And we'll make a statement, someone will make a motion here in a moment. And I just wanted you to feel comfortable that this is step one. It gets more technical and more input as you keep going farther. And Captain Henderson's role at the end will actually be so intense about safety and where those trucks are and where those hydrants are. I'm just saying that this is the beginning, and it is zoned, this property, and we're trying to stay really focused on what that one specific issue is about a setback. So I appreciate the emotion and the connection to the land and to the space and all that. And I also recognize the zoning is really what it comes down to. And then everything else will kind of continue to work on and be done. This will be a long process. We don't have the greatest Epic system right now, but even if Epic was at a lightning speed, I'd give this a year, of many things to go through. So I'm just trying to give you some light into looking at some of the questions that you're asking, some of the witnesses you're bringing in, Ms. Yamamoto, are really for the future. So I'm hoping that we've given you an opportunity to express yourself about the zoning and about this particular setback, and that's all I wanted to say. Thank you.
Thank you. Ms. Yamamoto, do you have any other witnesses?
I just wanted to say thank you, Mr. Davis, for sharing that and taking the time to just kind of clarify, and I really appreciate that. In continuation to what Mr. Davis said, I just wanted to point out, I do understand that we're focusing on the variance. I'm not trying to detract from that. I know that's what's, the issue on the table today. I think what I was trying to say with, Captain Henderson, having my next witness, Ms. DeMello from civil engineer number 4 from the Department of Public Works. I just wanted to really just kind of highlight that I understand that there is a process, but I feel like there should have been some comments from the various departments before the planning director made his decision because of the project of it in and of itself. And that's the only point I was trying to prove, is that I feel like there should have been some commentary in regards to this variance being approved from other departments before doing so. I understand that that's not the way that things flow, but I just wanted to highlight that I find that to be kind of backwards, not logical to me personally, that the variance got approved before other departments could comment. I do have a last witness, and I know we're trying to stick on the topic of the variance, but I did call her here via subpoena. So I would just like her to, I'd like to ask her just a quick question about her knowledge on the project, and that'll be the end of my witnesses.
Well, when Captain Henderson comes back, we can release him as a witness if you're done with him. But in the meantime, you can actually, Captain Henderson, I believe we're done with you as a witness if you need to leave the Zoom meeting. In the meantime,
thank you, appreciate it.
Thank you. Crystal, you are calling Melanie DeMello.
Yeah, Melanie DeMello, civil engineer and reform from Department of Public Works, as a witness.
So Melanie, do you swear to tell the truth on matters before the Board of Appeals today?
Yes.
Thank you. Crystal, you can proceed.
Hi there, Mr. Mello. Thanks for being present. I just wanted to, ask you a question. I know that you were aware of the proposed construction, but there has been no comment from Public Works Engineering Division about the project itself, because permits have not been, no applications for permits have come through your department. Is that correct?
Yes, that's correct. Similarly to Captain Henderson, we typically wouldn't be involved in the setback variance process, but we would see construction plans at a later date for permits.
Okay, that's all I wanted to ask. Thank you for coming today.
Thank you. Does the planning department have any questions or cross for Ms. DeMello?
And Jean Campbell for the planning department. No, we have no questions for Ms. DeMello. Thank you.
Does the board have any questions for Ms. DeMello? Seeing none. Ms. Yamamoto, do you have any other witnesses that are relevant to the matter at hand?
I do not.
Okay. Does the planning department, we'll move to the planning department's witnesses.
Good morning, Jean.
Good morning, Jean.
Good morning, Jean Campbell, Deputy Corporation Counsel for the Planning Department. We have only one witness. We'd like to call the director, Zendo Kern, please.
Aloha.
Mr. Kern, aloha. Mr. Kern, do you swear to tell the truth on matters before the Board of Appeals today?
Yes.
Thank you.
Okay. Good morning again, Jean Campbell here. I have only very minimal questions for Director Kern, if they've been more than one. Director Kern, what was your reasoning in granting this variance?
Thank you for the question. Good morning, all. So when we look at a variance, we have to take multiple things into consideration. And what we do is we look at the zoning as one and we see what the density is. In this case, as planner Mr. Nakayama already pointed out, the maximum density here would be 23 units with a maximum height allowance of 120 feet. What's important to me when looking at a variance is how does it affect the surrounding community, nature of the community, while still honoring the zoning and the property rights associated with that property. In this case, the zoning is a multifamily residential, 1,000, which will allow for those 23 units. And so when you look at it, it was a rear yard setback, which is going to be pushed up against other apartment buildings there and wouldn't be pushed towards any other single family residences. And we look at what the proposal was that the variance was based on. It was based on duplex units that were separated, which kept the character more in a single family residential nature, which would be a little different than what would be really permitted there and buildable there, which would be more of a long strip type apartment building. And there would be no variance and there would be no entitlements required for that. And so when we looked at it and it was 16 units with that type of character and that two-story nature, to me, it made a lot of sense to grant that variance. That was really where we were coming from, is how does it affect it while still honoring those property rights? And to me, it fit the balance of both of those. I would like to say that I've never met the applicant. I do not know the applicant. We look at it from a application standpoint. And in a time that we have a need for housing, and one of the biggest challenges we have for that is infrastructure. And in this case, you have a property that meets the general plan, high density, you have infrastructure, and you have a need, and you have somebody willing to do that. And you also have an applicant that was, in my mind, trying to create a project that was, again, a little bit more in keeping with that side of the existing apartment buildings. So based on that, we approved the variance and it met the criteria set forth in a variance application and approval. And if the variance is not upheld, the chances are that it'll probably be a long strip apartment type that would be different, not as good in my opinion, but very much entitled.
Thank you, Director Kern. That covered everything that I have. I don't have any further questions.
Thank you. Ms. Yamamoto, do you have a cross for Mr. Kern? You're on mute.
I don't have any cross for Mr. Kearns.
Board members, do you have any questions for Mr. Kearns? Mr. Wiseman.
Yes. Mr. Kern, and as we know, this is a private roadway, and the setback would be required of taking some of that private property, is that right?
Not sure I understand your question properly. It is a private roadway.
The private roadway.
Yes.
Yeah. Private roadway, and the setback will remove some of that private property.
No, the setback is for the rear yard setback, which would be pushed up against the existing apartment buildings. The rear yard setback is 20 feet. So what the request was to push the buildings further back towards those apartment buildings, actually giving more relief off of the, or keeping the same front yard setback. So it would have no effect on the private roadway as far as its, where it's located.
So in other words, the variance on the setback is not taking any property from that private roadway. Is that right?
That is correct.
Okay. And if it did, wouldn't it be eminent domain?
No.
If it was the county coming and doing that, yes, but in this case, it's a private roadway and private properties, and they would have to work that out privately.
But could they go ahead and build that unit without that setback?
The current configuration of those units and those duplex nature require that rear yard setback. Based on the site and my observation of it and my experience in both planning and construction, a different configuration of the building could be done, a bit narrower and taller with no separation of green space in between those buildings.
All right, and you heard the witness, Ms. Bonk, before in testimony that you declared there would be no adverse impact. But wouldn't that, I mean, wouldn't you have to take a look at the neighborhood to determine that?
Well, in doing so, you also have to look at the existing property rights. So with 23 units entitled, there's no discretionary approvals. So they could come in for a permit to create 23 apartment buildings right now, up to 120 feet in height. Obviously, going to 120 feet is probably not practical. So when you look at the adverse impact based on the zoning and the setback, yes, correct. In my opinion, there was no adverse impact based on what's currently entitled. And further, that the setback is for the rear yard setback pushed up against the apartment building, and there were no objections from that apartment complex within this. And all surrounding property owners were notified within a 300-foot radius. So if it was, say, entitled for just like maybe say 2 single-family residences, and the variance would then effectuate 16, I would say that would have an impact. But that would be more of a rezoning type of nature. But what we're working with is existing zoning that would allow for the 23 units. So that's what we have to look at it, right? Is what would be allowed, what could be built, and what's the variance request going for, and does that variance request have the adverse impact? And in my opinion, I would say that the variance request had less of an adverse impact. I'm very empathetic with Ms. Yamamoto and the testifiers, and that's where I made the decision to approve it, because in my opinion, it would have less of an impact based on what is allowed.
And that took into consideration the increased traffic on the little street, et cetera.
Yeah, again, yes, because with allowable 23 units, with 2 cars, etc., that would be a greater impact.
But in balancing, in making your decision with the balance of all these factors on either side, does it always come down to accommodate a developer?
No, absolutely not. Actually, I don't look at it as from accommodating the developer. I look at it as how is it going to actually impact the neighborhood? How is it a plan? Does this make sense for the area? What are the impacts of that? What is being provided? And how is that going to work? So I don't look at it at all from the impact of the developer side, which is why this made sense.
Prior to issuing a permit and considering all the factors, do you offer opportunity for any objectors, their input, etc.?
Yes, the applicant is required to notify surrounding property owners within a 300-foot radius. They also have to provide proof of that mailing and that occurred. And in this case, if anybody wanted to reach out and have a meeting, we're happy to do so, which we did. We did meet with Ms. Yamamoto and Ms. Monk about it and explained our position and where we were coming from with it. And always happy to have a meeting and understand, the impacts it'll have around the surrounding property owners.
I see. Okay. Thank you, Chair. That's all I have.
Thank you. Any other questions from any board members? I do have one question for Mr. Kern. Is the variance approval predicated on the completion, once they go in for building permit, predicated on them building exactly what they're currently showing in their variance application? And therefore, if they change the structure, does that negate their variance approval?
The variance application was approved based on their representation of what would be built. So if they were going to change that, we would look at it differently. Because really, when you're looking at a variance, you want to look at it from what is the request and why is it there, not just necessarily a blanket variance. If they requested just a blanket variance, we would look at that as a standalone. But in this case, they would need to be compliant with what is represented.
So if they are to go in for building permit with a structure that wasn't represented in their variance approved application, they would have to submit for a variance all over again if they so needed one.
That's correct. And prior to doing submitting for a building permit, they would have to do a plan approval, which would come through the planning department. And we look at the variance that was approved, conditions that were within it, as well as, parking, landscaping, all the other requirements, have that approval first, and then it would move forward for the building permit process.
Perfect, thank you. I have no questions. Does the planning department have any other witnesses?
We do not, thank you.
I just wanted to note for the record, Ms. Campbell, Ms. Coco wanted to provide some input. I believe she's watching on the YouTube. I forwarded that to you. I'll leave that to you as to whether or not you want to provide that input. I don't think it's appropriate for me as Board of Appeals attorney to do so. So, FYI.
I did see your email. I don't object to it, but I don't feel that we need to offer it into evidence. Thank you.
So now we'll move into. Go ahead.
Yeah. Ms. Campbell, I'd like to address this question to you. Is it the policy of your department, when you represent the planning department, not to provide any written arguments of briefs when on appeal? Or is it case by case?
It's case by case. It's case by case.
Okay. All right, thank you.
Thank you. So are there any final arguments by Ms. Yamamoto first?
Yes, actually, I know I was asked if I had any questions for Mr. Kern. As he was speaking and being asked questions by the board, I started to think of some questions I wanted to ask him. Am I still able to do so?
Yes.
Okay.
Yes, you are.
Okay, awesome. Mr. Kern, can you hear me?
Yes, I can.
Okay, wonderful. So I just had a couple questions. I know that and I hear you, you're trying to, not make a large apartment building. You want to try to fit the character of the neighborhood, make it, individual duplexes and have like a little bit of some yard space and so on and so forth. So I do understand coming from that perspective. I had a couple questions. So I know, there was mention, I think a couple times, I think you and Mr. Nakayama had mentioned about, building upwards. So you said that it can, the project can be built upward of like 120 feet. Is that correct?
The zoning in that area would allow for that height, correct?
And 120 feet, is that, I'm not good at visualizing that. How many stories would that be?
It's around 10 stories.
Okay. So, I know you also mentioned, I think you said 23 units would be the maximum amount of units that the lot could accommodate. Is that what you, or could you clarify that for me?
Yes, that's correct, based on the zoning and the lot size. So the zoning is RM1, so that means multifamily residential 1,000. So it's one residential unit per 1,000 square feet of land. So you take that, times it by the square footage of the land.
So I guess, could you, to figure that out, wouldn't it be, or I guess I'm not sure. I guess I'm not sure how that works, but it wouldn't be just the land, the acreage divided by the number of units, right? Or is that?
No, that is exactly how it is. So you take the square footage of the land, divide it by the 1,000 in this case. In other cases, there are other zonings such as RM2, which would be our multifamily residential 2,000. And in that case, it'd be one unit allowed for every 2,000 square feet of land. But in this case, it's RM1, so it would be divided by the total square footage of the land.
Right. So the square footage of the land, it's like I think it's like 0.55 acres. So you just divide that square footage by 23 units, and then each individual unit would be
it's
greater than 1,000, right?
Correct. It's just shy of 24,000 square feet. So thus the 23 units.
Thanks for clarifying. Quick question. So you talked about the 120 feet upward, building upward, and that'd be like 10 stories. With every story that is made, there has to be a setback, right, for every story. So like I know currently it's a duplex, right? So there's 2 stories, and that and so because there's 2 stories, I think it's every story you have to have an additional 2 feet of setback. Is that correct?
Yes, there is that requirement for above that, but only for the side yards, not the rear yard, front yard.
So is it even feasible to because already like with the duplex, we're already cutting down from 10 to 8 for that washer and dryer. Like, is it even realistic to even build upward? You know what I mean? Because of you're already having constraints from the side yards.
Based on my view of it and review of it, yes, it did appear to be realistic to go upward. I mean, probably not to 120 feet, but 3-4 stories, certainly.
Christo, if I can just redirect you to the relevance of your question to the matter that we're hearing.
Yeah, sorry. Thanks for redirecting. I was just trying to, think. I'm not a planner. So I'm just trying to figure out, Mr. Kern's thought process and like his justification for, no alternative construction in his opinion. So that's all. I just wanted to get the minutia out so I could understand a little bit better.
Thank you. Do you want to move into your final argument or presentation?
Yeah, I do. Yeah, I do. Thank you so much, Chair. I would like to, at this time, I do want to address well, actually, at this time, I do want to share pictures. Oh, no, actually, oh, yeah, that's right. So they're in evidence, but I just wanted to reference some of the pictures that I had provided for exhibits, just to clarify, certain things on pictures, if that would be okay.
Yes.
Okay, perfect. Give me a second. Let me share my screen and then pull it up if I'm able to. Is everyone able to see my screen? Oh, can everybody hear me?
Yes.
Okay, great. So I just want to reference some pictures real quick. So this is just like a little, overview of the neighborhood. I had these different colored stars, right, to represent different vantage points of pictures I had taken. I just wanted to, I know there was, a question about this tape measure and what that meant. I just wanted to clarify with the pictures there. So the pictures that I'm going to show, I believe it's this red in relation to this vantage point, the red star here. So let me pull that up. Okay, so here's the picture of the project site. Here's our driveway, our private driveway. If you're looking towards Laniakala Street. So what this represents here is basically, so I wanted to figure out where the roadway actually started. So to do so, I looked at my deed. I measured the perimeter on the Laniakala facing end, and it was a measurement of 88.72 feet. That indicates to me that basically where the asphalt tire track here starts is basically where the roadway would be. I'm sorry, the driveway would begin. That being said, so the width of the current asphalt here to accommodate a single car is about 7 feet. And based on the deed, our deeds and the TMK, basically that private driveway should be 18 feet in width. So taking account the 7 feet here laid out by the asphalt, I added an additional 11 feet. And I just wanted to demonstrate that. So, the actual width of that private driveway is actually from the beginning of that tire mark here to this little tape measure here, meaning that if we're looking at the site plan and we're trying to do 32 parking spaces in a linear fashion all the way down the lot, you have to think about the actual width or the length of a single car, which is probably approximately from here to here, if average car size. I just wanted to make a note that the actual site, project site for the building and the yard itself is going to be very, very small. I think it's misleading because you think that it's the entire, unmanaged vegetation here. But truly, based on my measurements, and you think about the individual cars that are going to line this proposed project, the space that you're working with is very, very small. You can actually see Ms. Hayashi's apartment complex roof very close. I just wanted to, make it a point to demonstrate that the actual square footage for the building itself is going to be very, very small. And I wanted to point that out for everyone to see.
Ms. Yamamoto, I do want to express again that we did see the site plan, reviewed it.
Okay.
And did view all of your attached photos.
Okay. Yeah, I just wanted to clarify about the tape measure thing, so that there would be no question as to why it's there.
Perfect.
Yeah. Okay, that being said, I think I'm done with my pictures. And I do want to, at this time, address the planning director's grounds for approving the variance. As mentioned in pages 45 to 47 in the record on appeal. Let me go ahead and stop sharing my. Okay. Thank you. I just wanted to present some arguments to the planning director's grounds for approving the variance. So it's my understanding that when there's a variance in question, there's really three main criteria for a variance to be approved. One is special and unusual circumstances. Two is alternatives, and no alternatives, and the last is intent and purpose. So I just wanted to go through those systematically. And just kind of provide counter arguments from my side. All right. So special and unusual circumstances. There are special or unusual circumstances applying to the subject real property, which exists either to a degree which deprives the owner or applicant of substantial property rights that would otherwise be available, or to a degree which obviously interferes with the best use or manner of development of the property. So, I do agree with Mr. Kern, the subject property is long and narrow, but from my standpoint, I feel that this is even more reason to uphold the established setbacks as required by Hawaii County Code, not grant a variance permitting an owner to circumvent the law to increase profits. The intent and the purpose of the code is to create space for light and air, and this is compromised by granting this variance. I believe that the owner should take the dimensions and the size of their lot into consideration and scale back their project as to adhere to established setback requirements. Doing so would not deprive the owner of substantial property rights, but uphold the high standard of thoughtful planning practices set forth by the Hawaii County Code. And the best use of this small parcel of land is not the proposal of construction much too large for it to accommodate. Second point, alternatives. There are no other reasonable alternatives that would resolve the difficulty. I do believe that decreasing the number of units would allow for more space and permit construction that can adhere to setback requirements. Currently proposed construction has been the only option presented due to the number of units desired by the owner. And lastly, intent and purpose. So the variance is consistent with the general purpose of the district, the intent and purpose of this chapter, and the general plan, and will not be materially detrimental to the public welfare or cause substantial adverse impact to an area's character or adjoining properties. I just want to say that yes, the property in question is zoned for RM1 or multiple family residential, and adjacent properties are also similarly zoned as RM1. I just want to point out, zoning designation doesn't mean that the proposed construction should be zoning designation does not mean that proposed construction should not be carefully evaluated and thoughtfully considered. To the contrary, proposed construction should be scrutinized to ensure the best planning practices are upheld for the overall well-being of current neighbors and future tenants. I argue that proposed construction will have an adverse impact to the neighborhood and adjacent properties. The proposed increase in population density will not only cause significant congestion to future tenants and their neighbors from a proximity standpoint, but will also radiate outward, affecting already heavy and worsening traffic on West Lani Kaula Street. With the up and coming construction of Bank of Hawaii and Liberty Dialysis at the corner of Kino'ole and West Lani Kaula Street. As mentioned on pages 32 to 34 within the ROA, the adjoining properties that are intimately and adversely affected by this construction are owned by my neighbor Keiko Bonk and I. Our private driveway is our only means to access our properties, and a large-scale project on the small parcel of land directly adjacent to our driveway would yield significant traffic congestion, noise pollution, and raise privacy and safety concerns. These problems are the result of the proposed density increase and would immediately devalue our properties. That's what I wanted to say on that, and I just have some closing arguments, but I don't know if I'm ready to go there, or is that okay?
I believe we're in summation, so I guess was that your summation, Crystal?
That was just some points I wanted to raise against the planning director's approval of the variance, and then I just wanted to kind of do like a summary for closing.
If you can proceed with your brief summary, that would be great.
Okay, perfect. So in summary, my fellow neighbors and I do not agree with the planning director Zendo Kern's approval of variance 21-00068, which would allow construction of 8 two-story duplexes along our private driveway. It is our understanding that the landowner wants to maintain her current design plan to maximize usage of a lot too small for a project of this scale to generate more revenue from the proposed number of units. We would like our neighbor to scale down her project, adhere to zoning regulations, and help preserve the country style feel of the neighborhood we've come to call home. The number and size of those units on such a small parcel of land will directly and adversely affect adjacent properties owned by myself and my neighbor Keiko Bonk, and ultimately have a negative impact on the neighborhood as a whole. I would like to clarify that I understand that the county zoning for the property is multi-residential and that Ms. Coco has a right to construction. I'm simply asking that she follow the same rules and regulations that all landowners, including myself, abide by when responsibly developing their property. I'm simply asking the board to have the foresight to see that it will set an inappropriate precedent for future construction. Zoning regulations such as proper setbacks help to ensure adequate light and space for the well-being of current and future residents and their fellow neighbors. Approval of this variance compromises this, sets bad planning practices, and will drastically decrease the overall quality of life for current and future generations. My neighbors and myself believe that alternative and reasonable construction is achievable if done so with care and intention. Variances are exception to the laws, but are not good planning. Thus, they should only be granted when appropriately called for. Mahalo.
Thank you, Ms. Yamamoto. Does the planning department have a summation they'd like to present?
We do. Thank you, Chair. Jean Campbell, Deputy Corporation Counsel on behalf of the Planning Department. Our hometown of Hilo is becoming more dense and it's growing up whether we like it or not. We have a housing shortage countywide, and this project in the department's determination would help to alleviate that housing shortage. It's consistent with the surrounding neighborhood in that there are already multi-story apartment buildings on either side of this project, despite the little tiny neighborhood that it sits in. In the case of this particular lot, it's already zoned multifamily residential, as you've heard. So if this variance is rescinded by the board, this owner will be forced to go ahead with likely a more dense construction than what's proposed. The director's decision for this variance was reasonable because, as he noted to you, his evaluation was that allowing a slight rear yard setback, which abuts an existing multi-story apartment building in the back, would have a positive impact on the way that the project would be constructed. It would allow separate buildings with green space in between versus one large, complete bank building that would block all air and light in between. And so the variance actually allows what could be constructed on this property to be less dense rather than more dense. So a variance in this case is actually good planning. It's better for the neighborhood and it's better for our hometown. It would provide housing that we desperately need and is as consistent as this can be for this neighborhood. So we thank you for your consideration on this, this appeal that was filed a year ago, and the department looks forward to moving the project along. Thank you.
Thank you, Ms. Campbell. May I get a motion from one of our board members on this case? Mr. Davis.
I make a motion to affirm the planning director's decision in the PLBOA 2021-00004. Did I get enough zeros? Finding the director's decision was not clearly erroneous in view of the reliable, probative, and substantial evidence on the whole record. It was not in violation of the code or other applicable law. It was not arbitrary or capricious, nor was it an abuse of discretion based on this information provided.
Thank you. Is there a second? Mr. Henderson?
I'll second the motion.
April can, any discussion? Mr. Wiseman? You're on mute, Mr. Wiseman.
Although I'm in favor of development, so long as it's balanced, and it is a hardship for long-standing residences like this family here, the families in this neighborhood, to have such a major intrusion into their, half a century or more neighborhood. However, the planning department, I think needs to take more interest and more human outreach with the neighborhood tenants and the people, and to add those to the balance that he has to implement and make a decision. That's all.
Thank you, Mr. Wiseman. Any other board members for discussion? Seeing none, can we call for a vote?
Yes, Madam Chair. We have a motion to affirm planning director's decision. Mr. Davis?
Aye.
Mr. Henderson?
Aye.
Ms. Psyche, excuse me.
Ms. Psyche, you're on mute. We need an aye or a nay.
Aye.
Mr. Wiseman?
You're on mute.
A reluctant aye.
Chair Aguiar?
Aye.
Motion passed.
Okay, so Ms. Campbell, as the prevailing party, will ask you to prepare a form of the order within 14 days of today, provide it to Crystal, or Ms. Yamamoto, excuse me, and we will thank and excuse everyone for this matter. Ms. Yamamoto, you and all of your witness, great job today, and please stay in touch with Ms. Campbell, and hopefully Member Davis's information will be helpful to you going forward, you know, regarding the other processes in which you can address your concerns. So at this point, I think, Chair, it's a good time for a break for all of us to make sure that we can get our next matters in, and we will again thank and excuse Board Member Vice Chair Henderson. Vice Chair Henderson, our next meeting is going to be on October 14, 2022 at 9:30 in Kona at the West Hawaiʻi Civic Center, because the next two matters that we have remaining involve conflicts in which you are recusing. So thank you, Vice Chair. Everyone else that needs to rejoin us, we will be back here at 1. Chair, are we doing a 45-minute break? What are we doing?
If we can.
Yes,
Unless
that
anyone
means
wants to have a lesser.
board members, 45-minute lunch break. Anybody
1
have a request? Perfect, okay.
Okay.
Anyone opposed to that? Seeing none? All right. Then we will reconvene here. It's now 12:17 at 1:02 p.m. promptly. Chair Henderson, Vice Chair Henderson, see you later. Thank you, sir.
Thank you very much.
Thank
Thank you, Chair Aguiar.
Make it 103.
I'll see you,
1:03 p.m.
David.
Thank you. Thank you, Ms. Yamamoto, Ms. Funk.
Thank you, everyone.
Thank you, everyone.
103.
Well, looks like the gang's all here.
We are, David, but you requested 103.
So we have one more minute.
We have another minute.
It's just my bargaining nature, you know.
I appreciate your negotiation skills.
Yeah, in court, if, you know, someone says, Your Honor, can I have just a couple, you know, just a minute? I said, take two. Anyway, I'm ready.
Because we announced 3 and it's on our YouTube live Zoom screen, we'll have to unfortunately wait until then, but it'll give us a chance to make sure Ms. Rohr and Mr. Myers are all joined appropriately with us. Mr. Myers, do you want to check your camera, sir?
Did. I clicked my camera, it's not on.
Under, at the video section, Mr. Myers, and you know, I'm.
Yeah, it says start video and I press start video and nothing pops on.
You click the little, there's a, by stop video on the right, there's a little arrow pointing up. If you click that, what are your options?
It says integrated webcam, blur my background. Then that's checked, yes.
Okay, that's all I have as well, sir. I don't know what to tell you. I'm sorry. Yeah, that's what mine shows.
Me too. While I was gone, I tried to fix it and I thought I did, but sorry. Is there a share screen supposed to be up?
Do you have a shared screen up, sir?
Yeah, it says shared screen.
No, you don't want to do that quite. I mean, you don't want to do that right now, sir.
Yeah.
Right now, we just want to
try.
Yeah.
If you click on video settings, it opens another window. Can you do that?
Okay. Yes, I did.
And so underneath the black screen, there's a section that says camera. What does it say in that box?
It says
with the drop down?
integrated webcam.
And that is. And if you look below, does it say always?
It says original ratio and HD.
Yeah, that's all you can do.
Yeah, I don't know
So
what's
it means your webcam is on. It's just
it
not
must
working.
be something with your camera, Mr. Myers.
Yeah, I'm sorry about
Because
that.
all of ours are identical. Yeah,
Okay.
something must be wrong with your camera, sir.
All right. Well, as long as
Sorry,
yeah, no problem. Is Claudia up?
She is, sir.
Okay.
And she has a video as well.
Yeah, I see her. Yeah, I'm sorry about my video.
No, it's okay, sir.
Yeah.
It is beyond 103. Are we ready?
Yes.
I think Claudia was raising her hand. Let's see if she.
Oh.
I do not see all the board members' photos. You
They
have
are
to
all
show the video.
They're all on.
They have under the amendment of the
They're all
Sunshine Law.
They're all on. So we have David Wiseman, BOAD Wiseman, that's board member Wiseman. Next, well, on my screen anyway, we have Chair Aguiar, that's number 2. We have board member N. Psyche, that's our 3rd one. And then we have board member M. Davis, that's our 4th member. And that's everyone joining us today, ma'am.
Oh, great. Haha. You normally have 7 people, right? Oh,
So
well, that's all right. That's all right.
No.
Cody, that's all right.
So we did start this meeting, Ms. Rohr, excusing one of our members who is not present today. And as you know, one of our members has recused himself, but we do have quorum and we're ready to proceed. That being said, we are back in session from our break for the September 9th, 2022 Board of Appeals hearing. And just for good measure, I do want to review our Zoom meeting protocols for all participants, please. All cameras must be turned on at all times during the hearing. One person speaks at a time with no side conversations. Mute your device when you are not speaking to improve audio quality for all. Raise your hand either physically or by your computer icon or reaction. And wait for recognition before speaking to ensure we have a clean and clear record. Prior to speaking, please state your name so that all parties know who is speaking. Speak slowly, clearly, and be close to your microphone. Limit distractions. Example, turning off your mobile phones and other devices. We have a very full calendar, and as necessary, we will take a break should anyone need one. So if we can get started, we are back to old business, and we will start with case Ian Myers, PLBOA 2021-000008, adoption of findings of fact, conclusion of law, decision and order, appeal of decision by the Department of Public Works Director regarding notice of violation and order. Location 75-437 Hualalai Road, Kailua Kona, Hawaii 96740, TMK 3-7-5-017-008. Can I get the names and appearances of the parties for this matter, starting with Mr. Myers, please? Mr. Myers, if you want to unmute.
I am Ian Myers.
Thank
Present.
you. Perfect, thank you. Ms. Rohr? You have to unmute.
Good afternoon. My name is Claudia Rohr. I land planner for Mr. Myers. I have 2 degrees in landscape architecture and took planning classes and had my own business here in Hawaii called Hawaiʻi Land Planning and Design. It's no longer, it was a trade name. It's no longer up on the Bregg's website, but I did have it. I have practiced land planning in Hawaii.
Thank
Good
you.
afternoon, Chair, members of the board. My name is Sinclair Salas Ferguson. I'm Deputy Corporation Counsel. I represent the Department of Public Works in this matter before you, the appeal of Ian Myers. Thank you.
Great, thank you. Are there any other parties that I haven't recognized? Seeing none. So we are here today to adopt the proposed findings of fact, conclusions of law, decision and order as filed by the department on February 9th, 2022. Since then, Ms. Rohr, appellant's representative, has filed a motion for reconsideration on September 7th, 2022. The department filed an opposition to that motion for reconsideration the following day, September 8th, 2022. I know that Ms. Rohr has filed a couple documents seeking to amend the petition in this case, but I've already denied the request. As to the motion for reconsideration, if the board members do not have any questions for the parties, can I get a motion to deny the appellant's motion for reconsideration? So board, Mr. Wiseman.
Yeah, I have a concern motion for reconsiderations. I usually file within a time period. I'm not aware that there's allowance under the procedural rules or statute here. I'll defer to legal counsel in that subsequently. But a motion for reconsideration is attempt to relitigate the case unless there's an intervening change of law of controlling law, the availability of new evidence, or unless it's an egregious, to prevent egregious manifest injustice. And I state that also with filing what I see as an 11th hour motion. Fortunately, the government had an opportunity to respond in 1 or 2 days. I mean, motions are usually given a wide berth, like 2-3 weeks for response back and forth. So, yeah, I just wanted to make that statement prior to any motion.
Does any other board members have a statement to make or want to, Matson Davis, a statement or a motion?
I'd like to make a motion to adopt the proposed findings of fact and conclusion of law in the decision and order filed by the Department of Public Works on February 9th. We went through this quite extensively. Yep.
I will
Mr.
second.
Wiseman.
You're ignoring my hand up.
Point of order, Chair. We have a motion. It's procedure.
And we have a second.
I'm seconding the motion.
Thank you. Seeing that we have a motion and a second, we will go to vote.
You have not presented my factual findings, conclusions of law proposed.
Ms. Rohr,
Point of
we have
order,
denied
point of
your
order.
motion for consideration.
Point of
So
order.
the board is now going to vote.
Point of order, please. Point of order, may I say it? I have submitted for Mr. Myers proposed factual findings, conclusions of law, and decision and order. I will bring it up on my screen. You were to have been emailed the copy.
Chair,
I will bring it
if I
up
may,
on my-
this is improper procedure now. What she wants to present is part of her motion for reconsideration, which is on the floor for a vote. It's been seconded, and the chair is going to take a vote on it now.
So if I can clarify the
I
motion
disagree.
that I'm speaking.
Oh,
If
give
I can
me a
clarify
break.
the motion,
Come on.
the motion that Mr. Davis has made is for adopting the proposed findings of fact and conclusions of law. If we are going to have a motion on the appellant's motion for reconsideration, I need a motion to deny or approve the motion for reconsideration. I think we should start with a motion with that first before we can adopt the findings of facts. So the first motion that needs to be addressed is the motion to reconsider this case or deny. Mr. Wiseman.
Yes, I will make a motion to deny appellant's motion for reconsideration. In this case, 2021, 5 zeros and an 8, based on the Board of Appeal rules 1-6 and 3-20, as this board cannot, under those rules, reconsider this decision.
I second that and appreciate the clarification. I apologize.
Thank you. Appreciate that. So being that we have a motion and a second, can I get a vote? Oh, is there any discussion? My apologies. By the board, any discussions on this motion in front of us?
One discussion for proper rule procedure under Roberts, and I'll defer to Cody. I think we have to withdraw the other motion or act on that.
Yeah, you're correct. So Mr. Davis.
I withdraw that motion.
Okay.
Thank you. Any other discussion?
I have a question. This is Ian.
Go ahead, Mr. Myers.
I was just wondering, they're not going to even to review the facts and findings? Is that what they're saying?
Yes,
They're
so
not,
what,
they're not even gonna read it? What's the problem?
That's,
we are not going to read
May I-
it because the motion has been made that it is out of our board's jurisdiction to be able to revisit this case.
I believe you still have a responsibility to read Mr. Myers' proposed facts and findings and conclusions of law.
Right
Right now, we are only voting on the motion to deny the appellant's motion for reconsideration.
And the reason for
That's
that?
it.
Let me give you the rule, Mr. Myers, if this would be helpful to both you and Ms. Rohr and board members. Under the Board of Appeals Rule 3-18, which is titled Issuance of Decisions and Orders, I'll skip to the part that's relevant here. It says a party to the proceeding may submit a proposed decision and order, which shall include proposed findings of fact. The proposed decision and order and findings of fact shall be served on each party to the proceeding, and each party shall have 15 days from the date of service thereof to submit written comments or objections to the board. So in this case, Mr. Myers, Delilah Schluter was a deputy corporation counsel at the time, and following the hearing, in fact, the same day, she submitted to both yourself and Planning Board of Appeals her proposed findings of fact, conclusions of law, decision and order, which is currently before the board for consideration. And at that point, sir, under our rules, you had 15 days to object. So the filing submitted by your land planner and representative, Ms. Rohr, is not timely because it was not within the 15 days under our board rules. And that's why Chair Aguiar is indicating that it wouldn't be considered at this time because we're now, 7 months to the day later on, sir.
I still think that I should have an opportunity to make a statement for Mr. Myers before you proceed. Hello?
We currently have on the table and
you're currently violating his right to due process. And I have a right to make a statement before you begin.
Mr. Wiseman.
Yeah, first of all, we have a very competent legal counsel and advice of the, in particular, the opposition, which stated the rules, which actually deny our jurisdiction from hearing this once the order is mentioned. And I think in all, with due respect, Mr. Myers,
I still have
the matter has, I have the floor, Ms. Rohr. The action, it had to mark, you had your day in court as they speak. The agency's decision was a final one. It wasn't a tentative or interlocutory one where you still have an opportunity. And the action which was done determined rights and obligations. And it's finished. It's a day in court. There's no, in our rules provided that public policy favors the need for finality of proceedings like this. So, sorry, but we should proceed with the vote on the motion, Chair.
Thank you, Mr. Wiseman.
She has her hand up.
Mr. Myers, we cannot hear it because of what we've explained. So this is, right now, we have a motion to vote on this proceeding and we are putting it to vote. So I apologize, but as Mr. Wiseman did explain, we've heard your case and really that it's out of our purview right now.
Actually, you voted on a motion by a non-party about something that Mr. Myers did not appeal. So this is going to be a invalid thing anyway, just to let you know.
Can we proceed with the vote?
Yes, thank you.
Mr. Paz is the appellee. He did not appeal the November or the March 1st NOVO. He did not appeal it. This is fraud on the board. This is fraud on the board. And he has a responsibility to get it on the record right now that this is fraud on the board right now at the very beginning, and that's the law. So we've done it. Take care.
Chair,
Mr. Weiss.
the board should not be tolerating accusations of impropriety or fraud like Ms. Ward just stated. And I'd just like to move for the vote, please.
Yes. Can we take a vote?
Yes,
April.
Madam. Yes, Madam Chair. Motion to deny the motion for reconsideration. Mr. Weissman?
Aye.
Mr. Davis?
Aye.
Ms. Psyche?
Ms. Psyche, you're on mute.
Aye.
Chair Aguiar?
Aye.
Motion passes.
Thank you. This closes the matter on this case.
Proposed findings of fact.
The proposed findings of fact are now what is in front of us. Can I get a motion to approve the proposed findings of fact or adopt the proposed findings of fact?
Could you please make sure the board has a copy of Mr. Meyer's proposed findings of fact? The board secretary was to email everybody. Heather sent them an email.
Chair, I believe Mr. Davis had his hand up for a motion.
Mr. Davis.
Yeah, I make a motion to adopt the proposed findings of fact.
I will second the motion.
Thank you. April, can we? Oh, any discussion? My apologies. By the board, any discussion? Seeing none, we can move to a vote.
Oh, hang on.
Oh, Mr. Sinclair.
One minor detail. I reviewed the findings of facts, and finding of fact number 5, I'd ask that one sentence be inserted at the beginning of finding of fact number 5, and that sentence would be that on December 28, 2021, the Department of Public Works filed a motion to dismiss. And that's all. Thank you.
It was the 8th of December.
Are there any other questions or discussion by the board? Seeing none, can we move to take a vote?
I have one question, please.
Yes.
Propose after the motion to dismiss was granted, is that the time that the board, I wasn't here, of course, but is that the time the board requests proposed findings of fact?
Yes. And the proposed findings of fact were disseminated.
Yeah, is that requested from both parties or just the appellee?
I believe it can be submitted by any party to the case, and it was submitted by DPW on February 9th to the appellant, and there were no objections filed against that findings of fact.
Thank you.
Pardon me, you did not instruct Mr. Myers that he could submit his own findings of fact. I read the transcript and I wrote it in one of my motions that you failed to instruct Mr. Myers that he could file findings of fact, conclusion of law, decision and order. Are you muting me?
No.
No. So I'm going to jump in, Ms. Rohr. Our Board of Appeal rule that I recited for the record earlier at the start of this conversation clearly indicates that Mr. Myers had 15 days from the file date of February 9th, 2022, in which he received the proposed findings of fact, conclusions of law, decision and order by the County of Hawaii's Department of Public Works. The rule very clearly states that he had that opportunity. So Mr. Myers, the rules apply to everyone, including yourself. As you know, Ms. Rohr, you are very educated in your ability to participate in these proceedings. So he had the same opportunity. As to clarification,
because Chair Aguiar specifically said who was to submit the findings of fact, conclusions of law, and decision and order. It's in the transcript, and it's Chair Aguiar who said who was to write them up, and she did not notify Mr. Myers that he had an opportunity to submit findings. And because she said it, it sounded like an order or some sort of, decision. And you have to look at the transcript. The transcript says Ms. Aguiar said it. Okay.
So that's accurate. You are correct. One moment. You are correct, Ms. Rohr. Chair Aguiar, in essence, ordered the Department of Public Works as the prevailing party, as we have done all morning so far for other unrelated matters. Typically, the prevailing party is responsible for drafting the proposed order. That does not preclude anyone from also submitting their own, and the rule very clearly allowed him to do that. So he was not prohibited from submitting his own proposed order, which you seem to be implying. So I just wanted to clarify that that's why the Department of Public Works drafted the order, because they were the prevailing party. He was still allowed to submit. Board Member Wiseman, go ahead, sir.
Yeah, I wasn't aware of that rule that both parties, usually it's a prevailing party who is asked to submit proposed findings of fact and conclusions of law.
That is not the law.
Don't interrupt me, please, Ms. Rohr.
Okay, go ahead.
I'm courteous to you, and I'll listen to you, and I won't interrupt you. I'd like to say.
Go ahead.
So, this is usually the prevailing party, but the opportunity for the other side is gone unless there's an objection to different things in the findings of fact, which usually can be dates and times and the sequence of things. So I don't know. That's just my understanding.
That's accurate.
And that is one of our board rules, that a party to the proceeding may submit a proposed findings of fact.
What rule would that be?
3-18.
What part of that rule says that the prevailing party? There is no prevailing party written in that rule.
It does not specify, but it does avail both parties to speak into the record, which Mr. Myers had within 15 days of being issued the DPW's findings of fact. With that, I want to move to vote.
Just to clarify,
I would like to be heard, please. Point of order. You guys keep cutting me off. I would like to say something. You are reading your rules so narrowly in order to make this decision that you're trying to say right now. The rules, because you actually said what you said, Chair, because of that, Mr. Myers has a right to submit his findings of fact because you misled him. It's called misleading somebody, and he's pro se. And you, by reading your rules so narrowly as to throw him out at the Board of Appeals, you're violating his right to a fair hearing, due process, and it's just outright mean. He waited 3 years, he filed on time, and he filed for something that that isn't even in the motion to dismiss. He filed decisions dated October 14th, 2021, written in a letter from Mr. Paz to him, answering his questions that he had waited 3 years to have answered. Now you're trying to say he doesn't have a right to file findings of fact, conclusions of law, when it doesn't even seem like Chair Wiseman, or not Chair, Member Wiseman has definitively said that they rule out filing, considering you misled him. If you had said nothing, maybe, but because you said what you said, you misled him. He's pro se. He didn't have an attorney. He didn't even understand it was a motion for summary judgment. It was presented as a motion to dismiss, not a summary judgment motion. Summary judgment motions under Rule 56 of the Hawaii Rules of Civil Procedure say you cannot file one less than 50 days before a hearing. So the quote motion to dismiss was filed right before the hearing. You know, it was like, okay, it was 30 days before the hearing.
David, you're muted. Board Member Wiseman.
Yeah, I'd like to make a motion to go into executive session to consult with the board's attorney on the powers and et cetera. On that.
Right, second.
Thank you. Okay, at this time, the board will be going into executive session. So we will be leaving this.
Yeah, we're gonna set up a
Zoom
separate
room.
room.
Just one thing, I think you have to take a vote on it. Don't we require?
Oh.
We do, and we need a discussion before we formally do that. One moment.
So is there a discussion? Any other board members have anything else to say before we take a vote to go into executive session?
Board Member Davis?
I'm sorry. I had that up from previous. I apologize. No discussion.
So can we vote? Mr. Wiseman?
Yes, aye.
Mr. Davis?
Aye.
Ms. Saiti?
Aye.
And Chair Aguiar?
Aye.
All right.
So we are, so the board members need to log out. Oh, no?
If everyone could just wait 1 moment, we're getting some technical assistance. So Ms. Rohr, Mr. Myers, Mr. Solis Ferguson, and all other non-board members will be moved to a waiting room just briefly while we go into executive session.
We're gonna move the board members to a different room.
Oh, okay. So you guys stay. We'll move the rest of us. We'll be back.
Okay.
They're still gonna be on the phone.
Make sure I'm muted. Hello? Yeah, you just did, girl. Way to go. Way to get off. Sorry about that. I cannot believe they don't want to even read the fact finding. Let's just make sure you muted. Yeah. Okay.
Is it done for today?
No. No.
Okay. Cody, you're on mute.
Okay, we're up. She had to plug her computer into her car. Everybody good?
Chair, yeah. Unmute Cody.
Can you hear us now?
Yeah.
I can hear you
So
now.
sorry. Sorry about that. Thank you, everyone. Ms. Rohr, are you
okay.
ready, ma'am?
Claudia?
Yes.
Great. All right, we are all back from executive session. And so for the record, in executive session, all board members were provided.
What is that?
Sorry, if I could start all over again. For the record, while we were in executive session, all board members were provided and have reviewed and read for the record the appellant's proposed findings of fact, conclusions of law, decision, and order document. So we are back in session, have both documents, and Mr. Davis.
I would like to amend my motion. I want to make a motion to adopt the proposed findings of fact and conclusions of laws with the change, recognizing that the filing date was actually December 8th, not on December 12th.
Wait, filing
Thank
date
you.
for what? Filing date for what?
The department's motion to dismiss.
David. David, unmute.
Can I get a second on Mr.
Just a clarification on the motion. That's the motion adopting the proposed findings of fact of the government. Is that right?
That's right. Department of
I'm
Public
not
Works.
getting.
Ms. Rohr, can you not hear us, ma'am?
It's not transmitting, it's intermittently stopping. I'm trying to see if there's something I can do on my end, if you'll hold on for a second. It's like a power thing, but I don't know where to find it. Hold on. Oh, I found it. Hold on. Okay, hold on. Could you try speaking so I can see if it's transmitting? If that didn't?
Mr. Davis, can you repeat your motion?
Yes. I amend the motion I made to adopt the proposed findings of fact, conclusions of law, and decisions of order as filed by the Department of Public Works on February 9th, recognizing that the filing by planning was done on December 8th, not on December 12th.
Thank you. And can I get a second to that motion? Mr. Wiseman, you are on mute.
Yes, I second the motion.
Thank you. April, can we, is there any discussion by members?
Ms. Rohr, you have a question. We're going to finish this motion and then we'll turn to you, Ms. Rohr. I see your hand up, ma'am. We'll get to you in one moment, ma'am.
April, can we go to vote?
You ready for the vote?
Yes,
Okay.
thank you.
Mr. Davis?
Oh,
Mr. Davis is on mute.
Mr. Davis?
I think you'll
Aye.
want to hear what I have to say. You'll have egg on your face at the end if you don't let me tell you what else is wrong with your motion. Okay, go ahead. That's fine. It's
Okay,
called
Mr.
a
Davis?
null. That's fine.
Go ahead, Claudia.
Mr. Davis, Chair Member Davis, your vote, sir.
Is a yes. Can you hear me?
Yes, sir. Thank you.
Mr.
Okay,
Wiseman?
thank you.
Yes.
Ms. Psyche?
aye, yes.
And Chair Aguiar?
Aye, yes,
Motion passes.
thank you. Ms. Rohr, Ms. Rohr, you're on mute.
The Department of Public Works is a non-party. You should have amended it.
Thank you for your comment, Ms. Rohr. Okay, let's see.
So should we take a 5-minute?
Just to clarify one more thing, so let's see. Anything else, Mr. Solis Ferguson?
No, thank you.
We had Ms. Rohr's last comment. Go ahead, sir.
I don't have anything further from the DPW. Thank you.
All right, so we will execute as amended the findings of fact, conclusions of law, decision, and order with that one amendment. And we are ready, Chair. I believe actually there was a request. We have one more matter, Ms. Rohr. I know you're in your car, so I want to make sure that you are ready to proceed with our next matter. We're going to take a short break. Do you need some time to get set up in your house, or will you be in your car, Ms. Rohr? Hang on, you're muted, ma'am.
Claudia, you're
Mr.
muted.
Solis Ferguson, you're done.
Do you
Go ahead,
hear
ma'am.
that?
No, they didn't
I
hear
can
you.
hear you, ma'am.
Okay, can you hear that weird coming in and out?
No, ma'am.
No.
Okay,
hear you
this
fine.
is what I'd like. I would like to turn my pad off for say 10 minutes and let it charge using this fast charger and then proceed, because you've kept me kind of online for a long time and it's just dying, and I have a fast charger in my car, but of course it would be more ideal to be inside, but I can I can turn it off and it will charge faster, but that means to log back on, and Heather will have to call me if it doesn't work out.
So Ms.
I
Rohr,
will
we
try.
will take a break for 10 minutes and let you get situated. And then we will get back online and reconvene at 2:10.
Okay, and if I don't come back on, please have Heather call me.
Someone
She
will
got
call
me
you, Ms. Rohr.
connected up.
Yeah, well, someone will call you if we have
Thank
any
you.
issues. Heather is not available right now, but someone will call you. And if you could be inside Ms. Rohr's setup, because I want to make sure that you don't go in and out, that maybe it's your Wi-Fi, I'm not too sure. I just want to make sure you're good to go. So we'll see everyone at 2:10.
Okay.
And Mr. Myers, your case is paused, sir. Thank you so much and have a great day.
Thank you, Mr. Myers.
Thank you, sir. Afternoon, everyone. Can you hear me? All right. One moment, please. We are just waiting for Ms. Rohr to join us. As soon as that happens, we will start. We can't start without her. So one moment. Sorry, everyone. Thank you. Noe, if we can just get you to turn on your camera. We are almost there.
Oh, are you hot in there over there or something?
Yeah, working up.
Yeah. I seen that fan, or is that the breeze coming through your office there?
It's the breeze.
That's nice.
Yeah, I was doing a little housework, but you know how it goes. I'm at home. Anyway, ready. Sorry.
We are almost ready, board member Psyche. We are just, someone is contacting Ms. Rohr to make sure that she rejoins us.
Okay.
Yeah, that connection she had in her car is just going to be very challenging. We're going to hear it over and over again.
So we are live, board members, on our YouTube channel, FYI, and we are just trying to reach out to Ms. Rohr. One moment.
Is anyone in touch with Ms. Rohr?
She's trying to log on right now. We can see her.
Uh-huh.
Where's her?
Ms. Rohr, can you hear us, ma'am?
And you're currently on mute. We can see you.
Can you?
I can see her.
Oh,
I can see her.
I see her square. Ms. Rohr, you want to turn on your camera and unmute, ma'am? Just want to make sure we're all on the same page, and let's test your audio.
Can you test it? Do
Yes,
you hear
I
me?
can hear you.
Okay, I'm not quite set up right, and I want to warn you, I have 12% on my battery, and we'll do the best we can.
There you
I
are.
don't see
Great.
everybody. I don't see the whole group, so I need to.
All four of them are
zoom.
on.
Just a second, I need to get all the pictures. No. More. Where does it tell me that I can see everybody?
On
Go
upper
to your
right.
top right, view.
View.
You see that in the upper right corner, at least on mine?
Okay.
Click on the view.
Hold on. Participants? No. View. I don't see a view yet.
So under
I think
the
I
orange.
saw it. I think last time I saw it somewhere else. No. Mute, stop video, share content, participants, but that just names them. More, chat, full transcript, meeting settings. No.
It's
Upper right says view.
upper right, right under the header bar. There's a little.
Upper right under the header bar.
Are you on a computer, Ms. Rohr?
No, I'm on my iPad because you aren't able to connect me, and my iPad says that you took me out of the meeting. I mean, my computer says that you took me out of the meeting, and I believe that one of you accidentally hit that button and should check your settings to see if you can bring me back in the meeting. But I am trying to find.
Let's look for, I'd like to focus on getting you ready for our hearing, since you're only at 12%. Time is of the essence. So do you see an option anywhere that says view, or with a bunch of, a square with a bunch of little boxes? Anything like that, ma'am?
Oh, here, now when I turned it, I see it. Okay.
Great. Great. Click on gallery.
Gallery. Well, I think I did. It's gallery now.
Great.
Okay.
Excellent.
Okay.
Okay.
Sorry.
There you go. Perfect.
No
Perfect.
need to look at my, okay.
We're
Oh.
back from our break and we're continuing with the September 9th, 2022 Board of Appeals meeting, and we're moving on to agenda item number 4. Claudia Rohr, PLBOA 2022-000025, appeal of decision by the Planning Director dated June 6, 2022, Special Management Area Use Permit Assessment Application PL-SAA-2022-000057, and Special Management Area Minor Permit PLSMM-2022-000022, and Director's Decision dated June 17th, 2022, closure of complaint ZCV-2021-000037E, location 2212 Kalanianaole Avenue, Hilo, Hawaii 96720, TMKs 3-2-1-018-006 and 007 and 010. April, are there any public testifiers on this agenda item?
There are not.
So if I may start the case, can I get the names and appearances of the parties for this matter, starting with the appellant, please, Ms. Rohr?
Sorry, iPad is just using my computer as a stand. I'm Claudia Rohr. I live next door at TMK 3-2-1-18 parcel 5. I've lived here for 22 years.
Thank you. And for the planning department?
Good afternoon. Deputy Corporation Counsel Susanna Tiapula, appearing for Planning Director Zendo Kern, who has not been properly served. We do make him available today as a witness.
Thank you.
You do make him, I'm hard of hearing. What about being a witness?
Ms. Tiapula, can you please repeat your statement on Mr. Kern?
Could you turn your camera on? I read lips.
Her camera is on, Ms. Rohr. Susanna Tiapula. She's
Okay,
on
hold
camera.
on. Okay, wait. Oh, sorry, Suzanne. Okay, let me focus on your lips. The last part about
Planning Director Zendo Kern is available and on the screen.
Is he available as a witness?
Yes.
Okay, thank you for your cooperation.
Thank you. And just as a point of housekeeping, if all parties can mute while you are not speaking, so the parties who are speaking can be heard clearly, and if you can speak directly into your camera, that would be appreciated. Thank you. So housekeeping again, April, can you verify that the appellant provided notice of today's hearing to surrounding property owners in accordance with BOA Rule 8-11D and has filed with the board proof of service of the hearing on the property owners within 300 feet?
Aloha, Chair. We're looking in the record right now. Give us just a moment.
Thank you.
Madam Chair, I don't see it. I wonder if you could ask the appellant what date she may have filed it.
Ms. Rohr, I'll look to Ms. Rohr. Do you know what date you filed the proof of service for notification of the property owners within 300 feet?
Hold on, I'm going to re-email it to you.
Do you know what the date is on that
I didn't memorize it. No, it was quite a while. I submitted a.
820. We found it. No need to email it. We found it. So we can proceed, Ms. Rohr. We lost you.
Thank you.
Okay. Before we proceed, do any of the parties, counsel for the department, Ms. Rohr, any other housekeeping matters we need to discuss before we can begin?
I filed 2 motions. I filed a motion and a brief. Do you want to begin?
Actually, the county would also like to let the commission make sure that they're aware that we will be objecting to the entry of any photographs or videos into the record that depict minors. And we can take that up at a later point, but we just want to make sure that that the screens aren't shared with photographs or videos until that's been reviewed.
Objection. I have videos that have been posted on the TV from View from the Sea, and the people must have given their permission to put it on the TV, so producing those won't have a problem. And my other videos with people in it, we'll decide later. We can always go into executive session.
Excuse me, but it's my understanding executive session is reserved for the board.
I've been in an I'm sorry. I've been in an executive session before with the Board of Appeals where they brought the parties into executive session. I have done that. Anyway,
So
let's just begin, please. I will not at the moment show videos of anything that has not been in the public view already, where the parties already gave their permission. Okay?
Thank you for that,
Thank
Ms.
you.
Rohr.
So if we can proceed with
can I proceed, please?
Actually, we're getting it going. So let the chair just say a few more things, Ms. Rohr, before we turn it over to you. One moment, ma'am. Go ahead, Chair.
So we'd like to proceed with the hearing. I'd like both sides to know that there have been a lot of pleadings filed in this case, including videos, etc. And it was a lot for this board to get through. With that in mind, if you can refrain from repeating what you have already provided us, know that we have read it or watched it and reviewed it. If either side begins to present testimony or evidence that is not relevant to our hearing today, you will be interrupted and stopped. There is one legal issue before this board, whether the director's decision in question should be reversed or affirmed. With that, let's begin. Ms. Rohr, will you be testifying yourself?
Yes, in the order in which I want to testify.
So when you proceed with your testimony, it's just a matter of the swearing in process. So if you want to start with your first witness.
I would like to start with the motions. The motion for summary judgment. Your rules say, okay. You're muted. Chair, you're muted.
Ms. Rohr, I will give you latitude and proceed with that. It's just typical that we hear witness testimony, and if I may address Mr. Wiseman, yes.
Yes, motion for summary judgment against at the risk of being repetitive. It's only when there's no material fact in dispute and as a matter of law, like there's two parties, he went to a red light and the other party agrees. There's no material fact in dispute. As a matter of law, he went through a red light, it's a violation. But here, with the voluminous documents that are on file, I'm sure there's many disputes. So how can we proceed to a summary judgment at this time? I make a motion that we reserve any presentation on the summary judgment until a later time. And the summary judgment is probably going to present all the facts that are in the petition. It just doesn't ring sound to me, you know. In other words, if Ms. Rowe was to say that the Department of Planning and the director, et cetera, is not going to dispute any facts she put in there that has some material consequences, then by all means proceed to a summary judgment. But I seriously doubt if that's the case.
Okay,
we were at a schedule for dispositive motions. Dispositive motions was on the schedule. I fulfilled my right under the schedule to submit that. And under your rules, it says that if the opposing party does not file an opposition, that you can take that as agreeing for the summary judgment. And I'm getting your rules up for you in a minute, please.
In other words, well, I'd like to hear from the government, the Planning Directors Council, if they're agreeing that you win the case.
We absolutely do not. Appellant makes numerous misstatements of fact and law, and her motion for summary judgment has no merit. Also, it's procedurally ineffective. The dispositive motions were due based on the first order, August 15th, 2022. When she failed to comply with those dates, the Board of Appeals gave her a second set of dates. Dispositive motions were due August 22nd. She submitted her first motion for summary judgment August 23rd. She submitted a second motion yesterday. So it was interesting when she cited rules of civil procedure, which don't actually apply in this, earlier requiring a 50-day notion. The Board of Appeals Rules of Procedure and Practice 2.4a provides that all pleadings should be filed within the time limits prescribed. Procedurally, her motion for summary judgment is ineffective. As a matter of law, it's ineffective. Nothing.
I disagree. I will find my email where I emailed you. Well, you weren't the attorney I emailed, so maybe you don't know. I emailed Jean Campbell. Let me find it. So sent.
Ms. Ward, while you're looking, was the summary judgment filed on those dates? Like
I filed it on the 22nd by email. Okay, let's not all talk at the same time. It's in an email.
At this time, because Mr. Wiseman has made a motion, I'd like to address that.
I'm confused why I can't find the email that proves I filed on time.
Ms. Rohr, we found it, and it was filed at 3:57 p.m. on the deadline date of August 22nd.
Right.
So that being said,
excuse me, Chair, is the email just a notice that it's going to be filed, or was it an actual filing of the summary judgment motion?
hold on.
Just to clarify, Ms. Rohr, we did find I showed Chair Aguiar the wrong email, so there's a little confusing. So Ms. Rohr, you did in fact file your motion for summary judgment on August 24th, 2022, pursuant to our scheduling order. It was due by 4:30 p.m. You emailed it at 10:15 p.m. And then you did a corrected motion for summary judgment, and that's the date and time that Chair Aguiar was referring to. I gave her the wrong email. So you, unless you filed it to Epic prior to 4:30, I just wanted to clarify that one point. You did do the date, but not the time pursuant to the scheduling order. I believe right now, just for clarity purposes, as attorney for Board of Appeals, I just want to note that I believe currently on the table, we have a motion from Board Member Wiseman to table the motion for summary judgment and allow the case to proceed to hearing. Do I understand that, Board Member Wiseman?
You have to clarify a little bit, Cody, for my hearing disability. You spoke very fast. So you're saying
Sorry,
that
Ms. Ward.
you said that originally I filed it on time on the 22nd, but not by maybe on the date. Did I file it on the 22nd?
Yes, ma'am, at 10 p.m., 10 something at night, and it was due by 4:30 p.m. So yes, Ms. Rohr, I'm saying you filed it on the right day, but beyond the time.
The rules say that it's by the date. And the scheduling order was given to me on the 17th. And it had to do with the fact that the planning department did not upload the entire record on appeal. And there was some issues with that. But the new scheduling order, you did put in 4:30. I did object to the new scheduling order. And also 4:30 is what do you call arbitrary addition. The rules state that, hold on. The rules state that it's by the date. And to put in a time is arbitrary. And I work full-time, 7 days a week. My husband is deceased. I have no one to help me. And I objected to the schedule to begin with. I did the best I could, and it's by the date.
So
not
let
the
me
time.
just interrupt briefly, Ms. Rohr. Our order is, our amended scheduling order speaks for itself, as I know you know. So I would say that you did, in fact, let's make the record clear. You emailed it on August 22nd, 2022, after 10 p.m. at night. You uploaded it into Epic the next day on August 23rd, 2022 at 9:38 a.m. So that being said, I've heard what you need to say, Ms. Rohr. We have a member with a motion, Ms. Rohr.
Please
So I
read
just wanna,
the email out loud because it explains that Epic didn't function and that it didn't upload. I notified you that when I sent it in the email on the 22nd, that Epic was not functioning. Please read that to the board. The content of the email.
If I may, Chair, at this time, we're not saying your summary judgment won't be heard. We haven't come to that conclusion yet. We're just saying that it'll be tabled, which means we'll hear it later, but it's not the procedural way we wish to proceed at this time. That's all. So as far as when it was filed, if it's late, I mean, it could be a technical error or whatever. That we'll deal with later.
And Ms. Rohr, for the record, we have seen and have received copies of every email you have sent. Every email you send goes into our files and records, and we must review them. So for that matter, I'd like to proceed with witnesses, and if you would like to call your first witness.
I would like an opening, please.
We have a motion that's pending, right?
Oh, sorry, Mr. Wiseman, your motion.
You don't have to do the motion. I will accept what you are suggesting. We don't need to do a motion.
But actually, acceptance is always welcome, but we really proceed on our rules. So Cody, can you proceed on that motion again?
I believe, sorry, Board
It's a
Member
motion
Wiseman.
to table the summary judgment until later, and let's proceed with the witness's testimony.
Okay.
So I don't know that we need a second and Ms. Rohr is agreeing, but let's make our record clear. Can I get a second, please?
Oh, Ms. Psyche, second.
Noi, if I could have our board members just unmute for simplicity purposes and be ready to respond. And I want to make sure we're sensitive to the time with Ms. Roar's battery life on her device. Noi, were you seconding that motion to defer
Yes,
the
I
MSJ?
second the motion.
Thank you. Is there any discussion, board members? I don't see any. April, can you do a quick roll call, please?
Yes. Mr. Weissman,
Yes.
Ms. Psyche,
Aye.
Mr. Davis,
Aye.
Chair Aguiar,
Yes.
motion passes.
Great, thank you, Chair.
So if we can continue, Ms. Roar, with your witnesses.
I am going to begin with an opening, please.
Proceed.
Remind me in 15 minutes.
What do you want to be reminded about?
Time is up.
Just a second.
Okay, added.
Are you getting this? Are you getting this?
What are we
What are we
supposed to
getting?
be getting?
Are you seeing my screen?
No, ma'am.
No.
Okay, press a button then. Hold on. Press a share screen button, somebody.
Who?
You have to press your share screen button, I believe.
What
I
are you trying to
did.
share, Ms. Roar?
I
Maybe
did.
can help you. What are you trying to
Content.
share?
I am sharing content. I don't get it. Okay, share content, screen photos. Hold on. Oh, website URL maybe. Okay, let's try this again.
If it's something from the record, Ms. Roy, I can help you. Do you have a particular item you'd like me to assist in sharing?
No, thank you. Hold on.
I believe.
Hold on.
I think it's
Yep.
coming.
Is it starting to share?
Yes,
Okay.
it looks
hold
like
on
it.
then. Okay.
It's still a white screen.
It is?
Yeah.
White screen. Hold on.
Nope, it's gone now.
I know. Hold on. I'm doing it again. Okay, hold on.
Ms. Roar, in the meantime, do you want to explain how this will be applicable, or what are we?
Do you see it?
You want? Yes. And maybe you want to explain how this will be applicable.
I have to stop it. It's applicable because I want my next door neighbors to know that I share their values and I applaud their project and I even applaud their educational program. And they can't be here today, so I would like them to have an introduction of their own.
I think that it's not relevant to your case.
It's my opening. It's my opening.
So we'll give you a little bit of time, and for the sake of time, we don't want to run out of time for you to proceed with your case.
It also shows that they're holding educational classes on the property. Are you able to see this?
Yes.
Oh, I was on mute. I just made a statement to myself. Chair? Can you hear me okay?
Yes, go ahead, Mr. Wiseman.
Yeah, what I was saying was, this is a half-hour presentation, and it looks
Yes.
very, very good. And I've seen a few of them on the University of Hawaii on the sea grants and stuff, and they're very interesting. Something I like watching in my leisure time. But for purposes of this hearing, which appears to be maybe quite extended with all the pleadings and everything and the matters to be considered, it doesn't seem relevant or material to the issue that we really need to decide here.
I've already made my statement that I did not want to proceed with this. I'd like to proceed with proceedings. I don't think that a welcoming video to express
Right.
her
So
neighbor's business is relevant
yeah,
to this case.
I would urge the chair to inform Mrs. Rohr that perhaps if we have time, we can always take a look at this at a later time. But right now, we should proceed with the matter at hand.
That's a great suggestion. Ms. Rohr, can we please proceed with the matter at hand, and
Okay.
we will
Okay,
be able to
I would like to present my first evidence that that Ka'umake Ka'eo Public Charter School is holding educational classes on the property next to me in violation of the zoning code, part 25-53B, without a use permit approved by the Planning Commission.
Can we take down this video screen?
No, this is my evidence.
May the county object? We've never seen this. This wasn't provided. The county has, there is currently a record. We've not had an opportunity to review this particular video, although we have watched the many hours of other videos that had been forwarded.
I sent it to the county. I sent it to them, to Jean Campbell.
So, Ms. Rohr, do you have any?
Yeah, Ms. Rohr, we're not going to watch this. We're not going to watch this now, so we might watch it later. But can you take it down, please?
It's my proof. I sent this to the planning director. Okay, I sent it to him in an email. So I insist that you not interrupt. At least give me 2 minutes. Do not interrupt. I sent this in an email. Now the county, the planning department's attorney is saying they never saw it. I want to at least establish that on March 1st, a TV program shows Ka'umeke Ka'eo Public Charter School held an educational class that was videotaped and put on the TV. And I also sent emails in at that same time complaining that, or I had sent in a formal complaint about educational classes being held on the property. So this is to establish that on March 1st, this was recorded and live streamed on TV or put on TV. If the planning department, well, the director's attorney wants to admit that, or if Zendo Kern wants to admit that he received this. It was before he filed the SMA permit. He did it like 4 hours later. He filed the SMA permit 4 hours after I sent him this video.
I have a hand up. Can I address Mr. Davis?
Yes. The issue at hand right here is this special management area application, correct? We are specifically looking at just this application and its approval. And if we, that's it. We're not looking at anything else. We're not looking at violations of use and zoning and everything. What we're looking at is, did the planning director and did the planning department correctly, is this the right thing to do with the list of things to go here? Is that correct? Am I missing something here? Because
that is correct, Mr. Davis.
Cody? Okay, so
that is correct.
Mrs. Rohr, I really appreciate your passion for this and the surrounding information that you're trying to bring. Is about this particular subject, just this subject, just this one.
Okay.
And so that's all we're looking at is it reasonable, and where these things appropriately approved, and that's where we're going with our motion. So you're muted now, Ms. Rohr, you're muted.
Okay, the CZMA, Coastal Zone Management Act, Chapter 205A, Part -26, 2C states that no development shall be approved in the SMA that is not consistent with the zoning code.
And this approval was for temporary, repair existing water lines, conduct some maintenance, clean out the ponds, conduct Hawaiian protocol.
No. I don't know. There is no such thing as a temporary SMA minor permit.
No, those were all the items on the application that
they were not all temporary. They tried to say
that's another issue. But Ms. Rohr, that's another issue then.
No, it's not. You are not.
If they have violated it, then that's a different story.
That's not my point. That's not my point.
Okay, hang on, everyone. Hang on, Ms. Rohr. And I appreciate the conversation, but this is a contested case formal hearing. We need to make a record, everyone. So if we are, I understand there's passion everywhere to make our point and or keep us on track. Thank you, Board Member Davis, but let's not speak over each other so that we can make sure that all of the important points and comments are being recorded for the record purposes. So I'm going to turn it back over to Board Member Davis, who had the floor and was speaking. Go ahead, Member Davis.
I'm complete. These are temporary. These were temporary items that were asked to be that were approved, that were applied for and approved, and some maintenance and such. So that I'm just trying to stay focused. I think it's really important, and thank you.
The
Thank you,
SMA
sir. So, Ms.
permit,
Rohr?
the SMA, this is my presentation, please.
How about we swear you in, Ms. Rohr, so we can let you testify? How about that? So, Chair.
Okay, wait.
So,
what are you doing now? Am I not allowed to make my case?
We are swearing you in so you can testify and make your case at the same time because you're also a witness to your own case.
Thank you.
So
okay.
if I can. So Ms. Rohr, do you swear to tell the truth on matters before the Board of Appeals today?
Yes, I do.
Thank you.
Okay. Okay. The SMA permit approves community events for 200 people. That's not a temporary thing. That is not an permitted use in the zoning code for residential RS properties under chapter, after Hawaii County Code 25-5-3 A and B. It's not listed as a permitted use. 200 people at any one moment. That means they can have 2,000 people come through the property as long as there's only 200 on site at a time. That is not temporary. The temporary things were the temporary thatched holly and 5 porta potties. So the first thing I want to testify about is my standing. I'm next door. I have ponds. They're connected underground with Hui Ho'olemalu's ponds. If those 5 porta, they are fronting the sewer. Rather than hooking up to the sewer, they got permission to put 5 porta potties. If you read all my submissions, you would have seen that I submitted my property tax records. They've raised my taxes to $10,000 a year, but yet I have to look at 5 porta potties and they're right next to my house. I run a bed and breakfast. I've run a bed and breakfast since 2005. They came because the planning department did not put in any screening requirements. They came in and cleared the property to the property line. I now have holes in the screening, even though I have screening on my side. They cleared a view to their tents. And now I have a view of a porta potty at breakfast time from my window at breakfast. And it's affecting my business. The conversation at breakfast now is, why are those people allowed to camp next door? Why are they camping next door? And I have to explain, no, they're not camping. They're a nonprofit and they are, holding outdoor classes, and those are tents are temporary. Anyway, the conversation is, why are there people camping next door? So I listed all the reasons why I had standing on my form petition. I amended that petition within the rules and expanded on why. I decided being right next door wasn't good enough. I had to actually say all the things that were interfering. So my property value is going to go down if 200 people can be next door every hour. If they open their classes at 7:30 and wake up my bed and breakfast guests, my rents are going to go down. I support what they're doing within reasonable conditions. I think that this minor permit, because it violates the zoning code, is just invalid. And the zoning code is applicable to the CZMA under 205A-26 2C. No development shall be approved unless it's consistent with the zoning code. So that's one point. Are you satisfied, Mr. Davis? Now you can ask me a question.
No, please continue, Ms. Rohr. This is your presentation of the case. This is not time for discussion. Please continue, ma'am.
Okay. I have to get up some, because I'm forced to use my iPad, I have to bring up the things I want to bring up. So bear with me. Okay, I wanted to show you, I got the wrong thing. I need to find the, this is my business's website. And I think you can see that people who are at, are you getting this?
Yes.
Hello? Okay. On the bottom left, you see people at breakfast with wraparound windows, and the view is of my ponds. At the upper right, you can see my building. And the photo on the bottom right is the front of my property. We bought 2 parcels, 1 acre, and we left the front parcel undeveloped. Whoops, hold on. And we feature wildlife, fish viewing. We say that we have Hawaiian ducks, which is an endangered species. And we actually have wild boar also. And it talks about the ancient Hawaiians who were highly skilled aquaculturists who stocked these ponds with choice young fish, and that they still have small native shrimp and edible fish, such as a holy and mullet, as well as our pet koi. And it talks about the fresh water flows down from the mountains underground to the lagoons on its way out to sea. These unique lagoons experience water level changes twice a day with the tides. It's actually 4 times a day. Thank you, Kamala, for educating me. But Anyway, I just wanted you to know that we have a different theme than they do next door. Our theme is rainforest and wildlife. Okay, so I need a different
One
exhibit.
moment, Ms. Rohr. One moment, ma'am. Board Member Psyche has her hand up. Thank you, ma'am.
Hi.
Go ahead.
Ms. Rohr, I believe we received this information and thoroughly read through everything that you have in front of us right now. So could we move on to something? For us?
I had no idea that by sending it to you, I couldn't present it.
Oh, we don't want to hear it over again.
Well,
we got it. We got it the first time.
I didn't get to testify about the meeting.
Oh, I understand the meeting.
Okay, then you know what? I will just testify to the meeting to all of my submitted material then, and we won't put it up. That's fine.
Without regurgitating, without talking about it over again from what we've read. It would be nice to hear something different if you have something different to share.
Okay.
Thank you.
Mr.
Hold
Wiseman.
on.
Yes.
I want to disconnect. I'm disconnecting.
One second, Claudia.
Yeah, the presentation, and like my colleague stated, we've seen this, we have it all. And it's very impressive and beautiful place and purpose.
That's not the point.
However, I'm not finished, Ms. Moore. However, it doesn't really go to whether or not the planning department did something wrong or gave a permit in violation of some code or some law or some regulation or improperly. It doesn't go to that.
It goes to standing.
We can, yeah. Well, there's no issue with standing, I don't think.
What?
I don't think standing is an issue here.
Well, I had to make sure that I let you know. So I've done that. If you waive the argument that I don't have standing, I'll proceed.
What was there an issue of standing? I'll defer to counsel on that. Cody?
Or Ms. Tiapula.
The county had not challenged her standing.
All right, so there's no issue of standing, Ms. Rohr. So we can move aside. And again, my compliments on a very fine residential area and the purpose with the wildlife and everything. It's I'm a naturalist at nature, so it's very impressive. However, it's not relevant.
I'll just testify to the items I've submitted and their relevancy.
Yeah, okay.
I submitted.
Again, it's not relevant to what we need to make a decision. Okay. Thank you, Chair.
What is it? Okay, I'll move on to my next presentation, which I won't put on the screen. My next presentation is an email that I sent to the director showing that Hawaiian ducks are an listed endangered species. I also submitted photographs showing nesting Hawaiian ducks and nesting nene geese. And endangered species is an issue. I also sent to the director the e-flyers for Hui Hole Maluo's outdoor educational classes for spring of 2022 and summer of 2022. I sent videos showing the Kaumeke holding one of their science labs, and the kids are yelling and screaming. And I also showed Kaumeke holding running races on Nene Street, yelling and screaming and blocking the road. Sorry. I sent in photographs of let's see.
Ms. Rory,
Pardon, what?
Ms. Rohr, I do believe we've received copies of all of those documents and
I'm
have.
not
reviewed them.
doubting you. Thank you for reviewing them. I am now repeating the evidence that Director Zendo Kearns violated Planning Department Rule 9. I filed a formal complaint on a form and submitted it, I believe it was the 16th in the summer of 21. They had, in the record is the inspection report, and then the closure letter states that there was no need to send a notice of violation. So the notice of violation did not go out. A closure letter was issued. I don't even understand what it says. And now that he's changed the SMA minor permit, when you read the SMA minor permit and the closure letter together, it's constitutionally vague. It can't be enforced. And one of the videos I want to show is Manoa telling me that he thought that the SMA permit covered their Olelo Hawaiʻi outdoor summer program. He didn't know that it didn't. And, but promptly after I said, I asked him the question, I said, did you see it in the permit? And anyway, after that day, they suddenly stopped their classes. So somehow they got some kind of advice. But I just asked them, did you see it in the permit? Now there is a video that I submitted where I explained to Manoa that I feel that the planning department has not helped them, that they've hurt them by not telling them what permits they need to apply for. They've just delayed, and that this permit that they got is unconstitutionally vague. They can't be charged with any violation because it doesn't seem like the planning department put it into written words. They met at the site with Kamala, Anthony, the agent for Hui Hole Maluo, Louisa Lee, who is the facilities manager of Ka'umake, Ka'eo Public Charter School. And they didn't put it in words after that. So somehow the plan, then they made an appointment to meet with the planning director. But still, they didn't get anything in writing saying what they had to do if they wanted to develop a facility for Ka'umake science lab. So if you will examine those two documents together, I think you'll see that first of all, the SMM is unenforceable because you don't understand what it's saying can happen. It says they can hold community events for up to 200 people, including, and they name some things, but it doesn't say for X. In other words, they can, in fact, Kamala is known for this, her Waiuli Water Festival, her brother and she started, the first time they started it, they had an electric band going all day. And the neighbors had to put up with that. So who's to say she's not going to do that now? You know, having an open-ended, vague SMM permit that is approving an activity community events that is not listed under the zoning code as a permitted use under 25-5-3 A or B. That is just not approved. Now I think that we need, I said this in January in front of the Planning Commission, that let's move on to the use permit hearings at the Planning Commission. I believe it requires an SMA major permit because of the wildlife and the sensitive nature. And my very first exhibit shows that with rising seas, most of that property will be inundated at 3 feet. And if you look at that website where you can check, it also shows that Kalanianaʻole will be underwater in 2 spots. This is under the amendment to Chapter 205A that was made, I think, in 2020, but it might have been in 2021. They have changed that chapter, and it's changed in that any property that gets inundated with high wash of the waves or flooding, whatever. I've lived next door to that property, and I think at least 2 times the wash of the waves came across the parking lot and into the driveway of that area. I sent you several pictures that I took during king tides recently. They came up to like a foot below the curb on their driveway off of Kalanianaʻole. And a lot of their property does go underwater. There is no record of how much land is submerged during these king tides. There's no survey showing that where the land really is. I believe that the so-called plot plan is not a real plot plan. It's using a bunch of symbols. But I would like to call my first witness, Director Kern.
Mr. Kern, do you swear to tell the truth on the matters before the Board of Appeals today?
Yes, I do.
Thank you.
Hello. Please tell me the dimensions of the parking lots.
Give me a moment to pull that up. The same dimensions that we were provided to you in the exhibit.
There are no dimensions.
They haven't come in for plan approval yet. At that point in time, they would provide dimensions based on what they're requesting.
How many cars can fit in those parking lots?
At this point, we don't know, as they'll have to come in for plan approval, which will show the parking and all of those elements to it. What was approved was an SMA minor permit.
Okay. Please explain the process of determining that that the property has a capacity to hold 200 people at a time.
They will have to do that. When we look at the SMA permit on their request and what they're asking for, which, mind you, is restoration of the ponds, stewardship of the land, and Hawaiian cultural practices.
No. Look at your permit. It says community events for up to 200 people. Is that a mistake? If you changed it, you didn't send me a copy.
Continue reading that condition.
What?
If you continue reading, and it says to perpetuate Native Hawaiian cultural practices.
Say the whole sentence, please.
Community events and curriculum development to perpetuate Native Hawaiian cultural practices and natural resource management, including fundraising, volunteer work days, ohana workshops, student symposium, makahiki celebrations, religious festivals, music and/or hula. Community events will be limited to no more than 200 people. They may have a bus that brings people in, people may walk. This is a tight community, and that will be up to them to work through that and maintain compliance with all rules and regulations around that.
Please tell me in the zoning code where it says that community events for 200 people are permitted.
We live in the state of Hawaii. This is Native Hawaiian cultural practices.
Please tell me.
They're allowed to do this. A community event is defined within a community event would be different if it's not connected to perpetuating the Native Hawaiian culture.
I don't believe fundraising.
I'm an advocate
Okay.
for perpetuating the Native Hawaiian culture.
So am I. I don't think you guys realize, but Mr. Myers is a Kanaka Ole. He didn't even bring that up, but I
Ms. Rohr,
respect.
please continue.
Huh?
Sure, that's not relevant to this case.
Okay. Well, he's implying that I'm not respectful. Please read. I included. Okay, I believe I included the constitutional amendment concerning Native Hawaiian rights. Could you please read the last line of, why don't you get up Hawaii Constitution, but I can do it if you can't. Hold on.
Are you asking, are you done with your witness?
No, I'm not
Mr.
done. I'm
Kern?
going to get you.
Oh.
No, I was going to, I filed a copy of the amendment that deals with Hawaiian, Native Hawaiian rights. I want him to read the last line.
How is that relevant?
The last line says that it qualifies the right and says that government has the right to regulate the activity. And the case law on that is that it has to be reasonable, but it doesn't mean that they don't have to get permits. And it doesn't mean that it also, the case law says it doesn't give them the right to self-governance. I quoted those two cases in my motion for summary judgment, I'm sure. Or at least I sent it in to the attorney for the planning department, the two case laws. But basically, one case is about 3 Native Hawaiians who went out to Ko'olave, and 2 of them went ashore to do some religious ceremonies, and 1 stayed in the boat. And they didn't get a permit from the DLNR, and they were, a boat came along and charged them with violation of the DLNR's requirement that you get a permit to go on to Ko'olave. And the court said that the Hawaii Constitution does not guarantee self-governance. They still were required to get that permit. It doesn't matter they were doing it for religious reasons. If they're doing something that's religious, then they need to get a permit for a church under the zoning code. It's either a church or a school. It doesn't matter which one. Those are the 2 categories that they can get a use permit for. I want them to be there, but lawfully. You're not helping them by not identifying the right entitlements to get. You're just stalling. You're hurting them. So if you really want to help them, you will realize that the Constitution says government can regulate the last line in the amendment. You can get it up. Just type into Google, Hawaii Constitution, the LRB. I think it's hard for me to remember. I think it's section 7, or is it, wait, article, it's not article 11, it's article 9, section 7 of the Hawaii Constitution.
Thank you, Ms. Rohr. I think you've made your point.
Okay.
Do you have
So
other
Zendo,
questions?
Kern, yes, of course I have other questions. Okay, so I'm wondering why the the SAA application was not sent to the DLNR, Forestry and Wildlife, local biologists for a consultation, because there's 2 endangered species on the property. Am I muted?
We sent it to the appropriate agencies, the Department of Health, County of Hawaii Department of Environmental Management, State of Hawaii Planning, Sustainable Development, State of Hawaii Department of Land and Natural Resources, State of Hawaii Land and Natural Resources, State Historic Preservation Division, as well as the U.S. Army Corps of Engineers. And in our review of the permit, all necessary communications with the appropriate government agencies were conducted as such.
Why did you send them an application that did not identify community events for up to 200 people? You did not submit the final application to those departments. You submitted a prior version, and it did not identify the intent to have over 200 people on a property with nesting and endangered species. That's my point. I'll move on. I guess I'm testifying a little bit, but do you want to answer that question?
Could you repeat the question?
Yes. You submitted a earlier dated application than the final one, and it did not list that they were asking for permission to have community events for up to 200 people. It did not identify that.
Objection, if I may. We've been extremely lenient, but appellant is misstating what was approved. There is no approval for events of up to 200 people. In the corrected permit that was approved, issued on June 17th, number 5, it specifically says that if there's going to be a community event, they have to seek additional approval. Appellant is misstating what was approved by the planning department.
No, I was not. It says that they have to get plan approval. It doesn't say they have to get plan approval every time they hold an event. It says that before they build their community buildings and hold community events, they have to get plan approval. That's what the permit, as corrected, says. Please do not misinform the board.
I apologize.
Okay.
Did send it out to the Division of Forestry and Wildlife.
Okay.
In addition
The
to
other-
all of the other agencies. I apologize.
The other agency you could have sent it to, and I can put this in the form of a question. I'm not sure if you're aware that there is an agency called, I hope I can remember how to say it now, Ahamoku. It's there's a local council. There's a council on each island. The legislature created this council for Native Hawaiians to, for local government like the county and or the state can confer with the Ahamoku Council on issues of Native Hawaiian rights. And so you could have sent the permit for them to review. But I guess my question is, why didn't you do that? But obviously you didn't know about it, right? Go ahead, answer my question. Why did you not send the permit out for their review? And I call it consultation.
Again, we sent the permit out to all the appropriate agencies and all the required agencies. We're also very, very lucky that we have a planner that has a deep background and also a background with the state DLNR to work on this. So there have been many very smart, intelligent minds that have worked on this permit. And we've sent it out to all the appropriate agencies, and I stand by that.
Okay. I got an email back from the the Commission on Water Resources, the Surface Water Branch, and I sent them what Alex Roy sent out to all the appropriate agencies. Anyway, they said that it never came across their desk and that they didn't understand the project. That's what they said. And before you sent it to the Army Corps of Engineers, I sent it out to them too and had a discussion. And they also kind of said, well, we don't really understand the project. But I told them, you know, yeah, that is sort of a problem, but what they're trying to do is X. And he said, well, if they're not using machines to clean out the ponds, then they don't require a permit. I accept that. But I did want to let you know that I have gotten back that response that they didn't really understand the project. But what was
Objection, there's
sent
no
out?
question in there.
Okay. So why did you send out a previous version of the permit and not the final version of the application? Sorry, why did you send out a earlier form of the application that did not mention 200 people and not the final version of the application?
It is my understanding that the application that was sent out to review was comprehensive of the request.
It did not include anything about 200 people. Okay. Why did you not send it to the fire department?
They would not be an agency that would review such a permit at this time.
How wide is Nene Street? Not on paper, on the ground.
I do not have that information right in front of me. Again, we looked at an SMA permit request for resource management, as well as Native Hawaiian practices and cultural rights.
Okay, let's see. So, do you, let me ask you, do you believe that my property rights have been implicated by your approval of this particular SMN permit.
Can you repeat your, can you repeat that?
Ms. Rohr, is that
Do
relevant?
you, yes, it is. Do you believe that my property rights have been implicated in your approval of the SMA minor permit on the property next to mine?
The county objects. That's not relevant to this hearing.
Of course it is. It's my constitutional right to have a hearing if my property rights are implicated.
Objection sustained.
Move on, Ms. Rohr. Thank you.
Do you believe that my right to a clean and healthful environment is implicated under Chapter 205A when you approved an SMA permit next door to me, including community events for 200 people?
Ms. Rohr, the objection was sustained. It was sustained by the chair, Ms. Rohr, so please ask your next question.
What do you mean? There was no objection?
There was. And you asked in essence the exact same question.
It's not
Ms.
the same
Tiapula,
question. It's not the same
Ms.
question.
Well, she
I'm
objected
not going to
again.
argue with you. I am implicating Article, now you have me all flustered.
Board Member
Article
Wiseman is
11,
raising- hang on, Ms. Rohr.
Article 11, Section 9.
Ms. Rohr, with respect to your questioning, I'm not aware of a dispute as far as you being an affected party. I think everything you put in shows that you could be an affected party. But we are here to decide whether or not the planning department properly issued a permit and whether it was a right permit and taken into all the factors of consideration.
Okay.
So that's where we're at. So we can.
The case law
is
that you cannot, under the Constitution, which is Article 1, Section 5, you cannot take away my property rights without holding a hearing, and it's not this one.
So, and that's Ms. Rohr, and that's what we're trying to decide.
Okay.
Whether or not all these factors were considered prior to issuing the permit.
No,
So
they didn't consider
not
my
disputed.
property rights. It's a dispute. They did not consider my property rights. And
we don't
if
know
they
that.
had, they
Ms.
would
Rohr,
have held at least one hearing.
Ms. Rohr, we're not going to get into an argument here. That's what we're here to find out. What they did consider, what they didn't consider. And
Well, that's why I asked him.
If what they didn't consider was, should have been considered, then we're going to deal with that. That's a factor.
Okay,
So please, let's move on.
Okay, that exactly what you just said relates to my question about whether he believes that he affected my property rights. And
well, again,
what is the answer to that?
His beliefs are not relevant to this hearing.
Well, did he consider it? You said you want to find out if he considered it. Did he consider it?
Ms. Rohr, one moment. We have an objection on the record from the department, from Ms. Tiapula. She has objected to this line of questioning, Chair.
And I sustain the objection.
So Ms. Rohr, please ask your next question. Please move on.
Did you consider me in processing this permit?
In processing the SMA permit, we considered all relevant facts that are required to process an SMA permit, and we issued a valid, legitimate SMA permit.
Well, you saying so doesn't mean it's true.
Next question.
Okay. I made a zoning complaint on a form. You received that, right?
We received a zoning complaint.
And on the 29th of, was it August, that you had a meeting with Hui Ho'olaimalua? After your inspectors went to the property and did a site inspection, they arranged for you to meet.
We did have a meeting after the site inspection, and we were able to communicate with the applicant what they would need to do in order to meet the desired outcomes that they were, which was, you know, again, restoration of the property, environmental stewardship of the property, and Native Hawaiian practices. And at the same time, we did speak that if there's a greater idea that they have, that there would be other permitting, but within this element that their request came in for, we approved the SMA permit.
Now, on the 30th of September, no, you know, a few days after the meeting, they submitted an application. And in it, they stated, and then they did what they called a, what do they call it? A master permit. It was filed as a master permit on Epic. They said their request was to build 10,000 square feet of buildings at a value of $1.4 million. And this was, and they.
Oh, died.
Everyone please hold. Everyone please hold. It looks like we've lost our appellant. Let's take a 5-minute break and see, hopefully her battery didn't die. Let's take a brief recess as we try to reach Ms. Rohr. Apologies, everyone. The time is now 3:44 p.m. Sorry, Board Member Wiseman, you are muted. You're still muted.
Just a FYI, I can't go beyond 4:30.
Thank you, sir. Understood.
So we will be back at, let's call a time. 3:48.
Sure.
3:48, we will be back. We're still waiting for Ms. Rohr.
That's a lot of wet, hot, sweaty bodies that you don't like touching. Think about it, Dave. I mean, is that what you're gonna do? Come on. Think about it.
Well, the already finish line thing I saw, but I'll check again.
Okay, we're back. Ms. Rohr, you have rejoined us.
Ms. Rohr, can you hear us? You're muted,
mute.
ma'am.
I can hear you, but where did we find that? Oh, I know. Never mind. Hold on.
Oh, and we're waiting for Board Member Davis to turn his camera on.
Thank you.
So we are rejoining from our break the Board of Appeals meeting. Just a matter of housekeeping, we do lose quorum at exactly 4:30. So if Ms. Rohr, you want to continue on. And I believe I believe Mr. Kern was answering your question.
I didn't complete it, but I want to stop and ask for a continuance next time my computer dies. I would like to, in advance, ask for this hearing to be continued. My computer may die and I won't be able to ask it later. So I'm asking, since it's so close to 4:30, if it dies, you have a choice of taking maybe a 5 or 10-minute break and letting me charge it, or continuing this hearing. But I won't be able to finish today.
Understood, Ms. Rohr. So if your computer dies again during this proceeding, we will take your request for a continuance.
Okay, I am asking for a continuance. I know I won't be able to finish today. So anyway, okay, I didn't finish my question.
Hold on.
We're not finished. Hold on. Go ahead, Cody.
So Ms. Roy, you've asked for a continuance, so we'd like to address that now, because I believe you indicated you'd like to just continue the matter, and I want to address the next hearing date with you before in case we lose you on with your device turning off. So
okay.
Our next board meeting is in October, Ms. Rohr, and parties, not just Ms. Rohr. That hearing date is on October 14, 2022. That is an in-person hearing in Kona at the West Hawaiʻi Civic Center.
That won't work for me.
Is that going to work for you, Ms.? No?
That won't work for me. That
no problem.
will not work for me. I need a Zoom meeting. Sorry. I think you know that.
So I am aware that I'm not sure when we can next accommodate a Zoom hearing unless we look at as far out as I believe we already have hearings scheduled in November.
Why do we need a Zoom hearing?
I can't address that at this time. I'm so sorry, board member.
Okay.
So our next hearing, other than that, is November 18th. And
what day,
after that, that's a Friday. It's always on a Friday, Ms. Rohr. Otherwise, we have December 9th, which would also be a Kona one, but we could see, since it's that far out, whether or not we could attempt to do all hearings via Zoom at that time.
November 18th is a key.
November 18th is okay. Thanksgiving's around the corner, right? After that?
Yes.
I believe so.
Go ahead. Let's do November 18th. And then I would like, I am again requesting that the board staff contact me with the Zoom invitation and get this problem worked out with my computer in advance.
So the Zoom registration link will be made available to everyone at the same time when the agenda becomes available. And if we have any issues, we can address them at that time. So the link is created, Ms. Rohr, at the time that the agenda is actually generated, which occurs approximately a month before our hearing. So we will not be able to generate and get you a Zoom link prior to. I'm sure we had no issues with Zoom initially, so fingers crossed that everything goes smoothly with getting you on there. So to clarify, you're asking to continue your hearing until Friday, November 18th, 2022. Is that correct, Ms. Rohr?
I am, but I think it's on your end. I've sent in all the error reports, so please review those. somebody removed me from the room, but you have several hosts with the ability to do that. So I don't know who did it, but it says that I was removed from the room.
It'll get squared away. I'm sure we will all figure out a way to come together again on Friday, November 18th, 2022. And that will be at 9 a.m., but a scheduling order, 9:30, excuse me. I believe what we can do, parties, and so this is Mr. Kern, Planning Department, witnesses, which I presume are going to be ordered back to the upcoming hearing. I think that's only fair so that Ms. Rohr need not subpoena the witnesses that were effectively served to return. I understand that to be the Planning Department witnesses. And I believe that the chair will issue an order, and we want to address one other thing for all parties, and this is going to be directed to Ms. Rohr and the Planning Department. Go ahead, Chair.
So I would like to confirm and affirm that the Second Amendment scheduling order still stands, so no further documents by Ms. Rohr or Ms. Tiapula on behalf of the Planning Department should be submitted, nor will we take them into matters of this case.
Does everybody understand that?
Yes.
Ms. Tiapula? Okay. Ms. Rohr?
I can't think of anything I would file. I've already filed 2 things that you folks have not acted on.
Alrighty
So
then.
that is affirming the second amended scheduling order will preside.
Excellent.
Thank you.
Okay, Ms. Rohr, who are you asking to have ordered back? I believe you have Ms. Campbell. Who do you have in the? Maybe we can have everyone turn on their computer screens or their cameras at this time.
We don't know who's here, but
Actually,
that's why I just asked them to turn on their cameras. So, Ms. Tiapula, who do you have in the Planning Department that has been properly served?
so the only person who was properly served was Clinton Mercado, and that's because when the process server arrived, Mr. Mercado actually physically took the subpoena from him and made his own copy. No one else was served and given a copy of the subpoena. We had made available today Zendo Kern, the planning director, also Alex Rohr.
Roy.
So I believe, okay, great. So thank you, gentlemen, for hang on, Ms. Rohr. Thank you, gentlemen, for coming voluntarily on behalf of the Planning Department. I appreciate your assistance. Chair, are you going to order all 3 of those witnesses to return at the next hearing date and time?
Yes, if they are, yes, I will.
So I understand that Ms.
I would
Tiapula-
like to say that my process server went back and reserved the subpoena, and the date is on what I filed. And we have a disagreement about that subpoena form. It has 2 boxes. It says serve the person or someone else explain. It's the same form that they use at circuit court. It has 2 boxes, and either the form is misleading or you're misleading the witnesses and saying that they have to be served personally.
I don't want your battery to die, Ms. Rohr. So let's get this handled on your behalf. So Ms. Rohr, the witnesses that you have properly served and or that are voluntarily appearing, I understand she's frozen. Okay, I understand that to be.
I'd like to just inform Ms. Rohr. With all due respect, Ms. Rohr, please refrain from accusing or implying any improprieties of the board. We are all here pro bono. All of us gave up a whole day. We don't get a lunch. We don't get anything. We're public servants, and we all have a high degree of integrity. It's really troublesome when you start coming out with these implications of impropriety among us. So please.
It wasn't directed
Think about
at
that
you.
and refrain from it.
I apologize.
includes
I
me, Ms.
I wasn't accusing you. Well, you know what?
So Ms. Rohr, let's focus on your witnesses because I'm trying to
You-
assist you in getting them ordered back. So you don't have to serve
They
them
will
again.
not
So
come
let's-
to the counter. They
No,
will
no,
not
Ms.
come
Rohr,
to the counter
if-
when my server goes there.
I'm trying to avoid you having to serve them again. I'm trying to have them ordered back to assist you so you don't have the additional expense of reissuing a subpoena and serving them. So if you give me a moment, I'd like to have our chair order to return at the same date and time, Planning Director Zendo Kern, Planning Inspector Clinton Mercado. I believe we also have Alex Roy, and thank you. Everyone we have there. So Ms. Rohr, I am trying to assist you in getting them to return without reissuing another subpoena. Ms. Tiapula, have I missed anyone in the conference room on behalf of the Planning Department?
Individuals, but these are the three that Clinton Mercado, she had technically served in some way. The other two voluntarily showed up. The planning
Great, and
director.
thank you for doing that. Thank you for doing that. I appreciate
I'm
everyone.
going to have. Please have.
Do you not want to order
the? Please have the planning department, the people I am trying to subpoena to agree to have the court counsel, a named court counsel, accept service for them.
So
I cannot
right,
make
hold
them
on.
come to the
Hang on.
counter.
Ms. Rohr, I am ordering without you having to serve them again that Mr. Zendo Kern, Mr. Alex Roy, and Mr. Mercado will be at the continuance hearing to testify.
I'm going to be reserving the rest of the people. Anna Lynn, who was properly served, but somehow you have made it, you've told everyone they don't have to come. We have a disagreement about it.
So you're free to reissue subpoenas if you want, Ms. Rohr. That's more than fine, ma'am.
I will, but
That is
I
fine.
would ask the planning department's attorney to please ask them all to allow you to accept service because they refuse to come to the counter.
I'm sure they will not do that, but please send an email to Ms. Tiapula and the members from the planning department that you would like to resolve subpoena issuance with. Just email them. If they will agree to Ms. Tiapula accepting the subpoena, that's all you need to do. Then you serve Ms. Tiapula with their subpoenas. You do not need to do that for Alex Roy, Clinton Mercado, and Zendo Kern. Do you understand? Are we on the same page?
You're saying I didn't serve Alex Roy correctly. So
No, we're not.
Alex, I would like to serve you again if you would please cooperate and give permission.
That is not necessary, Ms. Rohr. But you can. They have already been ordered by myself, the chair, to appear at the continuance hearing. Now, if we can continue the matter and button up the any other continuance housekeeping matters.
I would like to try to give a couple more questions to Zendo Kearns, please. So
are we
Holy Maluo filed, it's not 4:30, it's 4:08.
Ms. Rohr, we granted your request to continue, ma'am. So you can continue your questioning of Planning Director Kern at our next hearing date. You asked to continue, so we've granted your continuance. We've ordered Planning Director Kern to return, along with Alex Roy and Clinton Mercado. Everyone will be ordered back. You do not need to reissue those subpoenas. We've granted your request to continue the hearing for technological concerns.
And just to clarify, because we would be happy to communicate with the planning department to receive subpoenas, but only the individual she's already named. I just want to clarify that she won't have any additional planning department staff?
Correct. So the
Thank you.
witness list that was already provided and approved by myself is the extent to which she can continue. Ms. Rohrer, you can serve again if you choose.
And we will communicate with planning department to facilitate that.
Thank you.
Thank you.
I just want to let you, I want to let you know that the actions of the planning department personnel who my server was trying to serve sent him to the doctor. He was under so much stress.
Mr. Wiseman,
Yeah,
your question.
Chair, it's my understanding you mentioned there will be no further filings. Is that correct?
That is correct.
I would request that be put in the order of continuance.
Oh, wait a minute. I guess I don't agree with that because the planning director withheld part of the record on appeal that under 13-9 or 3, I'm not sure, 3, it says that he's to file the entire record on appeal if it deals with a zoning issue. And they produced it for me, but they didn't upload it. And it takes a lot of time to do that, and I didn't have the time to do it for them. But I would appreciate it if you allow the planning department more time to help Mr. Kearns upload the documents.
The county would object to not upload documents for another party.
And as
no,
the
it's
chair,
it's his. You're not understanding what I'm saying. You're not understanding.
I am understanding.
In my petition, I say he broke the rule 9, your rule about providing the entire record when there's a zoning matter. I have also sent you copies of the letters stating they weren't going to provide that. Now they finally did provide that 45 minutes before the drop date on something and did not upload it into the Epic system. Now he has, you want me to say that he can't do that? I think he can do that. It's their responsibility to upload it. It took me 2.5 days to try to find the record on appeal that they did not load up, but I'm tired now. I would appreciate it if the department staff will upload for Director Kearns those files that were provided to me on Monday. That's how late they were provided to me, Monday.
Okay, Chair.
Yes, Mr. Wiseman.
Yeah, the planning department's on notice about that. And Ms. Rohr, that's a fact that will come up. What they did do and what they didn't do is which one is right or wrong. That's a fact that we'll be listening to. So they're on notice about that. And
but I would like the entire record on appeal to be uploaded because I expect the county to, file
yeah, we understand your request. So yeah, but that's
okay. How about this? Will you give me 3 days to upload or send? I don't know how you want to do it. It should be the department that uploads it. They have the records. Could you please ask them to upload the documents that were provided to me on Monday that had been formerly withheld? Could they please upload those now, like in the next week, because we're not having a hearing for months. Why not allow them to do the right thing?
So
do you mind,
my question,
Zendo?
My question is to Ms. Tiapula, who has already objected, whether you feel that those documents are not relevant to this case or not.
Mute.
Oh, you're on mute, sorry.
Commissioners and Chair, we're not sure, sitting in this conference room, what documents she's referring to. If it's part of the record on appeal, it's already a part of the record. We don't know what email she's referring to. Mr. Zendo had informed me that he's received 178 emails from Ms. Rohr. I don't know what she's referring to. Anything that's part of the record on appeal, let me finish. Anything that's part of the record on appeal is already part of the record. She's provided more than 3,000 pages that she did manage to upload so far.
Thank you, Ms. Teokula.
I'm sorry, there's a formal letter to me saying that they were withholding the records on it, the records for my zoning code violation complaint. Now, they finally gave them to me on Monday. I doubt that Jean was the one who got emailed everything. Jean Campbell. Mr. Kurz was also emailed everything. There was the OIP came in too. But in any event, he relented on Monday and they sent me the records, but they did not upload it. But there's a letter saying they were withholding it from the record on appeal. And it goes to your board rules about ethics. What was uploaded was not the entire record. And they had an obligation to file a form saying what was withheld. And they did not do that.
Let me interrupt briefly, Ms. Rohr. Ms. Rohr, I understand, I believe, and I suspect that you're referring to a UEPA request that you did to the department, the planning department. Mr. Kern, are you aware of the production pursuant to a UEPA request that Ms. Rohr is referring to?
At this particular moment in this conference room, I couldn't speak accurately to that. But I do know that we are supplying, to my best of my knowledge, we're supplying every information that we can.
He supplied it, but they didn't upload it. They supplied it on Monday.
Ms. Rohr, I believe because there's great confusion on which document or what email is being referred to, you being the party who is disputing the relevance or the uploading of it, I am open to you sending a copy to me to assess the relevance of it, but at this time, we cannot order anything when we don't know what the document is.
Your own rules say that he was to upload the entire record when it concerned a zoning matter. So therefore, relevant or not to you is not the importance. It's whether I find it relevant. You may not find it relevant, but this is my case.
I have a suggestion here.
Yes, Mr. Wiseman, I am open to suggestions.
I suggest the order that you are going to issue after hearing, continuing the matter with a provision that no further filings, except for good cause. In other words, if there's a really good cause that Ms. Rohr thinks she needs, and she can put in something to get that document. Just a thought. But again, Ms. Rohr, what they didn't do is not going to help them. I mean, if you point that out and they didn't do something they're supposed to do, that's a fact that we're going to decide.
Okay, it's your own rule that says he has to do it. I expect him to honor that.
Okay. That's all
it's under your ethics. It's under your ethics rule too. You can't send something without saying what you're withholding. And under the rule, he was to upload the entire record.
Ms. Rohr, please don't lecture us on the rules or the law. Okay, you have a you have a, I know you probably know quite a bit based on your pleadings, but please, it's not your place to be lecturing us on the rules or the law, okay?
I'm not lecturing. I'm putting it in the record. That's
Well,
all.
you
I'm
made
not
this
lecturing.
statement.
Don't take it personally.
The chair has something to say because we need to get going. Thank you, everyone. If I could ask everyone to stop and let's turn it over to the chair so we can conclude.
So to conclude, we will be issuing a continuance order of which it will state that we are sticking to the Second Amendment scheduling order and no further documents will be submitted into the record. I think everybody's had ample time. I think we've spent a tremendous amount reviewing all documents, and Ms. Rohr, you will have your day to verbally express what you feel was withheld. And I think in this continuance hearing, you will have your time to present your case. So that said,
next hearing date, everyone, is Friday, November 18th, 2022, 9:30 a.m. I understand we need to do this by way of Zoom. The chair has ordered back Planning Director Zendo Kern, Clinton Mercado, and Alex Roy. So Ms. Rohr, you do not need to reissue subpoenas to any of them. We will, are you done? So we will, in essence, allow, we will reissue subpoenas with the next hearing date on your behalf to re-subpoena anyone that you failed to properly serve for this hearing if you want them to still join you. Is there anything else today? I don't see anything. Okay. Board Member Wiseman, go ahead, sir.
Yeah, I move to adjourn.
Is there a second? Thank you.
thank you. Second by Ms. Psyche and third by Mr. Davis.
Any discussion? I don't see any. Okay, great. Everyone in favor of adjourning for today, everyone please say aye.
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 Any opposed? No opposed. May the record reflect no opposed. Thank you, everyone. Have a great day. Have a good weekend. Aloha.
Aloha,
everybody.